Good morning, good morning, good morning. It's January. I can't believe it. It's Tuesday, January 14th, 2025. Where have the weeks gone? Well, the law's been very busy. And when the law's been very busy, it means we've been very busy. And today is no exception of us being very busy. Today, we are going to be talking about a few updates in the Karen Reed case. Remember, this case is coming up for retrial in April. It's going to get busy. By the time we get out of Q1 2025, it's going to be incredibly busy with lots and lots of days in court. And then Alec Baldwin is suing all of the prosecutors, and there was a new order in that case yesterday. I don't think I've seen that reported on yet. Maybe I missed it this morning, but there is a new order there, so we're going to talk about it. But first, we're going to talk about the quick updates in the Karen Reed case. And remember, new year, well, same me. She's too old to change, but small incremental changes, no jump scares, but new year streaming Tuesday, Wednesday, Thursday. So we will be back tomorrow with more legal goodness. And I think tomorrow, if we want, we might talk about TikTok some more. I'm going to wait and see what happens over the next few days. Remember, we stream Tuesday, Wednesday, Thursday up in here now. Quick Bits drops on Monday. So that was yesterday. If you saw it, let me know. But because of that, we can cover hopefully a little bit more in the cases we've been tracking. But today, normally, I want to go with like one topic a stream so they're easier on the playlist. There's too much going on today. Today. Elia Hall said, Emily, you've convinced me to get a ginger pondered. Possibly, we will see. They are mischief and managed, and they are delightful, and they are sweet, and they are goofy, and orange is the spicy variety of cat. But I love them. They are very different than some of the previous cats that I have been blessed to have in my house. So all of you, thank you so much. So many of you have said lovely things about me being on Peter Lawyer You Know's podcast. I feel like Peter is always like, this girl talks forever. Most people in my life feel that way, but I love having conversations with other attorneys. I really enjoy the way Peter approaches stuff. And I feel like his approach, though much more succinct than my approach, his approach is, hey, we might not like the way it is. This is what it is. This is what it is. Even if we don't love it, let's talk about the is of it and why it is. And we ended up just going down the rabbit hole talking about lawyers lawyering, because what do lawyers love more than to get around and talk about other lawyers? So we had a lovely chat on his podcast. We'll link it below. It was just a really lovely chat. I always enjoy getting to connect with Peter. It's a lot of fun. So lovely chat. The day I was streaming forever, when I was like, let's see if we can bump back the meeting, we did that. And for those of you who said, some of you were like, Emily, is your desk lower? It might be. Do I have an automatic spot in my desk yet? No, I keep adjusting it. Look, tragedy struck yesterday in my office as I've been trying to like rearrange some of the bookshelves. So everything is a little discombobulated because I ended up wrapping up what I was doing yesterday sooner than I thought, because I dropped a paperweight on one of my smaller toes. And so it was a rougher evening than I anticipated. That paperweight is no longer displayed anywhere. It's been banished to the other bookshelf, but it did not feel great. And here's the thing. I do not do stuff in my office without wearing shoes as a general rule, because I have dropped stuff on myself before. I've dropped stuff on myself before. It is not unusual. Sometimes in the ADHD realm of like spatial awareness, things get lost, and then you're like, no, everything's fine. And then everything's falling and you have bruises and you don't know where they came from. So it's an adventure always. But I had shoes on. What I didn't realize is that one of the cats had thrown up in my office. So I was moving around and delightfully stepped in that. So I was drying my shoes that I had cleaned when I bumped into something, and then the domino effect of everything falling. It was like that book scene in The Mummy where she's trying to stay stable and then it hits one bookcase and then they all go. It was like that. It was just It was just like that. So then everything happened. I don't think the toe is broken, but it is not great. So that was a day. If it doesn't, it was like it just is. If it doesn't go down with the swelling tomorrow, we'll go take a look. But I don't think it's broken. I think it is just banged up. So yay for me. So the desk did not get reset, but don't worry, we will be back to standing desk, probably not today or tomorrow, but we'll be back to standing desk and then you'll see it. So for those of you, I'm fine. It's an inconvenience. Tempest does stuff, thank you. And that's exactly what it felt like. Like the one thing fell and then everything was like, bleh. Like all of my shelves just everything. But we will see. So I might. Did I get nauseous? No. Is it bruised? Yes. Is it swollen? Yes, but not terrible. So, my EMT training came in handy. Yeah, I've just been trying to keep the toe up. Of the bones I've broken, I have broken fingers and I have broken toes, but that's about it. No larger bones. All those were soft tissue injuries. Christine said your spatial awareness means you hit your shoulder, you just had surgery on into a door. I've done that. I actually, though not my spatial awareness issue, right after I had back surgery, I was going for my follow-up appointment and somebody rear-ended me in their vehicle. That's a story for another day because we have lots of law to cover today. But imagine trying to call your person and say to something to the extent of, I got in an accident because I was on my phone. I was not, the other person was. This is the other person's perspective. I got into an accident because I was on my phone and the person I hit is a lawyer who had back surgery a week ago. Imagine that conversation. Like I actually felt bad because they were clearly very stressed. I was very stressed. I'm like, and my doctor was like, nah, your fusion is screwed all in there pretty good. It's going to be sore, but no, your back's all screwed together. It's not moving. So with the fusion, I was all screwed together. Well, but it did cause some soft tissue agitation, but I did feel bad for the person behind me as well. So for all of you, for all of you who have said that you love the Lawyer podcast, I'm so glad. If you want to hear lawyers talk about lawyers, go check it out. So with that, we're going to jump into the law. All of the Angelino law nerds and the law nerds who are worried about Los Angeles, the worry is warranted. Keep an eye on what's going on in LA. I have too. Family has been good but stressed. Air quality is absolute shit. I put up some donate links. There's plenty of places to donate if you can. I know that Bethany from Be Strong has been talking about the fact that donation centers are now overwhelmed with physical goods, and just overwhelmed with physical goods. If you can, you can. If you can't, share it. And it is okay either way. So just if you can share things, share them. If you can donate. I will be donating throughout the month to different organizations as they need. I will not be donating physical goods, unless somebody specifically needs them. So those will be like, hey, do you need this thing? 1-to-1, but the physical goods are handled. It reminds me of that scene out of Clueless. Again, back to movie references, because in Clueless, fires in Los Angeles are such a part of life. You always hope that people are prepared. I don't think anyone's prepared for hurricane force winds like they've been having. The winds are fairly unprecedented. And B, it was part of a plot line in the movie Clueless, because of course it was, because it is such a regular part of life in Los Angeles that it becomes part of the plot. And at that point, RK said it exactly. Cher is heading up the Pismo Beach disaster relief team and is bringing in her skis. And her teacher's like, I don't think they need your skis. And she's like, some people lost everything. And that includes sporting equipment. Here's the thing. With the sporting equipment, it is very hard to give goods. It is much easier to donate money and let people replace what they need. So, and Kate said, don't donate your bongs. We also learned that from Clueless, but they did put them in kitchen goods just in case anybody needed them. No, the Pismo Beach Disaster Relief Fund was for a fire, yes, but it was not a real fire. It was they picked a fire. So there is lots going on. There are humans and animals and all of the things that need help in California, and there is still ongoing stuff in North Carolina. Like, there is so much. So it's a lot. We're just going to talk about the law today and see if judges or lawyers or anybody's being shady. We're just going to see what lawyers are being shady. We're going to run away from the other people, a lot. We're going to run away from our own a lot, and we're going to focus on other people's law problems. That's what we're going to do. Plant Hoarder said, hey, some people lost their smoking equipment. Exactly. True. Twisted Life said, I don't think they need your skis. Cher, they lost everything. I mean, that's exactly what it was. So for all of you that are thinking of LA, for all of you that have reached out and asked, our families are well. Me and Dr. B and our extended family, we have friends that are not doing as well. It is tough. It's really tough. And again, I talked about it last week that my father-in-law lost his house in a house fire. It can change the trajectory of people's lives, and that's quite a lot. And there's a lot of that's going to happen in California, because though the news focuses on the names you may know that have lost their homes, there are many that are either living in generational homes or that have moved to Los Angeles when it wasn't quite as expensive as it is now. And those are life-changing losses. And it's hard to watch, especially knowing how that can shift trajectory. It's really just hard to watch. So, Sturga said, my stepmother lost her house in Altadena. She's 75 years old. And those are the stories that people don't talk about, that there is so much that's difficult. So, and Miss Tonisha, share and keep it on your mind. Not everybody can financially assist, and that's okay. But sharing it with somebody who might be able to is fine. So my daughter's 84-year-old in-laws lost their home in Palisades. And that's the part of California they don't talk about. And a lot of people in California, their homes are part of their retirement planning, and that's going to make things incredibly difficult. So it's also it's hard at the beginning of the year. It's always hard. Disasters are always hard. But if anything comes from it, it might be time to have all those really uncomfortable conversations. No, this episode is not sponsored, but it might be time to have those uncomfortable conversations about the adulting shit that's awful to talk about, like wills, trusts, where all the documents in your home are, if you've got those scanned into a hard drive in a safe box that you can grab and go, or one place where all of the most important documents are. It might be time to remember or to think about the fact that you've got to do all of the things, the adulting things, the life insurance, the checking your home insurance, renter's insurance, the documents you need, the prescriptions that you need, the wills and trusts, so you don't have to go through probate, all of those things that aren't a lot of fun, but are really necessary because stuff changes. So that's what it is. Let's see. Oh, Pat, this is a good, Pat, thank you. Pat said, Emily, if you go to the doc or ER, just know they don't tape broken toes anymore. Okay, I'll tape it myself. I just got put in a knee-high walking boot for 6 weeks. Apparently they've learned the foot and lower leg are impacted too. Damn it. I still might have to do it. Aaron said basic estate planning. Yep, it's hard. Not everybody wants to talk about it. These are also things to talk about with your extended family. And with your extended family, those aren't always comfortable conversations, but knowing where things are, knowing where they keep things, and having those conversations is needed. So for us, we have all of like the passports, the birth certificates, all of those things. Yes, we have stuff scanned because otherwise I will lose the numbers on it, but we have a separate hard drive with photos, with those documents, so we can just grab that hard drive. We have those physical documents all together. And then we have all the insurance policies and stuff like that all together, and then the prescriptions all in one place. So we have all that stuff, so we know where it is if we ever needed. I mean, in our area, it's less evacuating and more sheltering in place, but in sheltering in place, it is, we've got the hard drive with the photos and it'll be okay. So, all right, let us go talk about lawyers being shady and not talk about, well, we're going to run away. Let's go gallop away into the law together. I think, as I said at the beginning of the stream, I don't even think I've run the intro yet. 15 minutes in, we haven't run it. It's fine. Karen Reed, and then we're going to be talking about Baldwin suing everybody and a really interesting ruling that came down. I saw it late yesterday, so I don't know if anybody's covered it. We'll see. We'll see if they did. So no, for all of you asking, did I roll the intro yet? I sure didn't. Let me know where you're coming in from, what you're drinking. I brought the tankard of coffee again today. It was that kind of a day. It was just the tankard was needed. So we've got the tankard of coffee. Let's get into it, you guys.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not. Let's get into it.
Beloved said, I'm having tea in Prague. Not only does that sound delightful, but it also sounds like it needs to be a collection of poetry or short stories or something. Like it's just all of the things. Casey said, coffee reheated more than once. SoCal with iced tea, Pace, Florida with hot tea. We're going to bring all the tea. What's the tank? Oh, the tankard. It is a extra XL size coffee mug of all of the coffee. So it's great seeing all of you give your input and advice on like, hey, these are all the things. I think, is that Culver City, or Culvert? Two different places likely. Culver City today, tea started at 6 a.m. with coffee. Now it's water and tea. It's the hydration is needed. So it is all the needed. Arizona green tea, Western North Carolina coffee and cream, Washington State here. It's good to see you guys. Louisville, you guys got some snow. Nico said Finland with hot chocolate. That also sounds delightful. And Holly's coming in from Alaska. It's good to see all you guys. All right. Are we ready to talk about... Oh, it's dinner time in Germany. This sounds good too. Water and gyoza and a poke bowl. Gyoza and a poke bowl. Yum. We're going to talk Karen Reed first. These are quicker, as I roll my eyes at myself, quicker topics, but I know that we have not talked about what's going on with Trooper Proctor. Look, Massachusetts is not easy with documents. Some of these, when they get scanned in, look like just blurry. It is not you. It is not your monitor. You do not need to check your prescription. It is these documents. These documents in particular are just, ugh. But we need to talk about Trooper Proctor. So let's talk about Trooper Proctor first. I think it's appropriate to give a swoop as we talk about Trooper Proctor, and then we'll get to the court's ruling. For all of you saying, Judy, you got this. Trooper Proctor. Trooper Proctor is getting to the find out part. So this is the Commonwealth's updated notice. Remember, the Commonwealth is giving discovery notice about what's going on with Trooper Proctor and others. So this is that notice. In the trial of Commonwealth versus Karen Reed, or the trial of Commonwealth versus Karen Reed, began in Norfolk Superior Court April 16th in front of Judge Beverly Cannoni. Trooper Proctor testified in that matter on June 10th and 12th and was subject to cross-examination relating to alleged conflicts of interest, communication with non-involved civilian persons regarding the Reed case, and statements regarding the defendant from which defense counsel argued a bias could be found. Well, isn't that one way to parse it, isn't it? From which defense counsel argued a bias could be found. Okay, Morrissey. Sure. Or he was, or bias was there. Nobody had to go looking for it. It was just in the text messages. On July 22nd, the Commonwealth informed counsel and the court that Trooper Proctor had been suspended without pay and was the subject of an IA or internal affairs investigation. On January 15th, 2025, tomorrow, folks, Trooper Proctor is scheduled to appear before a Massachusetts State Police Trial Board for allegations of misconduct in the performance of his duties as a uniformed member of the Mass State Police. Upon a finding that there are reasonable grounds for discipline, the colonel for Massachusetts State Police may immediately impose permanent discipline. So, are they going to decide tomorrow? Are they going to decide tomorrow? Or is it going to be a few days? These will not be streamed. Linda D in the chat immediately was like, stream it? Is it streaming? It's not streaming. But we will, I think, see a decision because the finding of reasonable grounds for discipline, texting about that investigation with people not part of the investigation is wild. So we'll see. But he is, if they find reasonable grounds for discipline, they may immediately impose permanent discipline, which means he might finally get fired. Has he been fired yet? No. He has been suspended without pay, which is more than anyone else involved in this has suffered. Some people lost like a day or two of vacation time. Yeah. It says the Commonwealth expects the pursuit. I can't read. The Commonwealth accepts that pursuant to this court's March 20th, 2024 ongoing order, pursuant to Mass Crim 17, which is their discovery statute, the Massachusetts State Police will produce all responsive reports and records pertaining to the discipline of Trooper Proctor to the defendant and the Commonwealth at the conclusion of their IA investigation. Do you know what's interesting that they said there? Did you catch it? Did you catch it? I don't know if Morrissey even caught it. Records pertaining to the discipline. They said they may impose permanent discipline, and then they say pertaining to the discipline. So it's an interesting way to word it because it doesn't say, and we know that these prosecutors know the words to the discipline, if any. But what they say here is pertaining to the discipline. So do I think he'll be disciplined? Yes. Do I think he'll be fired? I'll be surprised. Well, I guess nothing that happens in Massachusetts surprises me anymore. I don't even know what to expect. I think there will be something happening. But permanent discipline, for those of you asking, I think permanent discipline indicates firing. So we'll see what happens. But this is the furthest any of these have gone. Remember, there is still due process. Regardless of what Trooper Proctor did, what Trooper Proctor said, there is still due process. So he has to go through all of these stages of hearings before they can fire him. He can't just be summarily fired. There are still things you have to go through. So do I think they're going to fire him? The language of this seems to indicate that. Ernie in the chat said he's getting rehomed. And do a different job. So we'll see. We'll see. Who is Morrissey in the Reed case? This is a very fair question because there are too many Morrisseys in today's show. Michael Morrissey is the elected district attorney in this county. So in Norfolk. So he is the elected DA. That is who he is. County might be the wrong word, but he is the elected DA. So we will see what Massachusetts State Police decides to do. And they've indicated to the court, this was from January 3rd. So a few days ago, but they indicated to the court that the hearing will be tomorrow and we will see. So we might know tomorrow at some point, Thursday, Friday, later in the week, we might know when Trooper Proctor will become or what will become of Trooper Proctor. So We will see. But Trooper Proctor, hearing tomorrow, permanent discipline may ensue. So we will see. For all of you saying, thank you for asking. I was confused as well. Perfect. That is exactly right. So let us get into our next ruling. Let me go make sure I've got it pulled up before we start talking about the road so far here, because it's a short ruling. It's a 3-page order from Judge Cannoni. This is faster than I expected, honestly, from Judge Cannoni, because some of Judge Cannoni's rulings have taken more than a bit. So I was pleasantly surprised. But let us get to this ruling, shall we? Who can forget the 2 days of Dauber-Lonigan hearings with regard to Dr. Russell in the Karen Reed case? Dr. Russell testified at the first trial with regard to the injuries on John O'Keefe's arm and whether or not they were caused by a motor vehicle collision or a dog. That was the sum and substance of that testimony. New Special Prosecutor Brennan brought a motion to exclude Dr. Russell, mostly on the grounds that there was no scientific methodology underlying the identification of the injuries on the victim's arm. Dr. Russell spent an entire day going through her extensive, varied, and I found very interesting resume, because not only had she trained as a police officer, she's also a treating physician. She had also worked as a coroner. She had also worked in state prison and in county facilities. She's dealt with people who, in the treatment of police dog bites and non-police civilian dog bites in the busiest ER, I think one of the busiest probably in the country, but for sure one of the busiest in the state of California at County USC, which also serves Men's Central Jail. And because of that, she wrote a peer-reviewed portion of a book on treating dog bites, because she had come across so many of not just police dog bites, but dog bites in the, real world personal context as well, of people who just got attacked by a dog. So her experience went on for a day, and then there was a half a day of cross-examination, a little bit more from the special prosecutor, getting to, and this is the special prosecutor's point, getting to, so you just looked at it, that's the scientific methodology here. You just look at it. You don't know if that bite comes from a canine, if this comes from that, if that comes from that. And she's like, I have treated thousands of dog bites. That scratch pattern didn't come from a Lexus. That didn't come from a motor vehicle collision. That's not road rash. And we know the prosecution is sticking with some version of, could those cuts be from glass or plastic? And I think where the prosecution had their strongest line of questioning was, did you check all of these other things? And there were some things that the defense just hadn't given to Dr. Russell. Could Dr. Russell review those now? Sure. But I think Dr. Russell did not articulate well, and Dr. Russell articulated lots well, did not articulate this well, in my opinion, was that the other information doesn't really change what those injuries visually look like. It doesn't change. You can give me all the information in the world, but visually, those injuries are in the pattern, she said, of a dog attack. So sure, you can give me more information, but when I look at it in an ER, I don't have all that information. When I look at it to treat it and to triage, I don't have all that information. When I recognize the pattern of injury, I don't have all that information, and I don't need it. You know why? Because I look at that and went, that came from a dog. And for a lot of you that have worked with animal, I've seen this in the chat time after time after time. You guys have said that you have dogs, train dogs, groom dogs, all of the things, and have said, in my life and experience, now it looks like dog. And a number of you have said, on Real Housewives of Salt Lake City, Bronwyn was attacked by the dog, and sure as shit looks the same as the injuries to John O'Keefe. So a lot of you have said from your own personal experience that you look at that and go, let's look at a dog. And some of you have shared from your own experience with motor vehicle accidents that you look at that and go, I don't know if it's a dog or not, but what I can tell you is that doesn't look like it's from a motor vehicle accident. And then when you compile all that together with the other evidence in the case, we will see what happens in the retrial. Let's get to the judge's ruling. Again, faster than I expected. And for that, we will be thankful. I'm always glad when we get to rulings quickly. HD said 100% thought the same thing about Real Housewives of Salt Lake City. Yeah, Bronwyn's had a season, right? We're gonna have to talk TV more. We need to talk reality TV more. Okay, I mean, but are you guys watching Traitors though? But are you guys watching Traitors though? When we get to Q of A, we're going to talk about Traitors. Karina and I were thinking the same thing. I mean, okay, when we get to Q&A, we're going to talk about Traitors because let me tell you, first of all, look, it's connected. Boston Rob. It's connected. Boston Rob. We're having a sidebar to talk about Boston Rob. Look, the way I was a Survivor diehard early 2000s, it was what my husband and I did every Thursday when we hang out. Every Thursday when we hung out, when we were dating, we would watch Survivor. I freaking love Survivor. Love Boston Rob. I'm going to try to not spoil Traitors, but if you watch episode 1, you're caught up because you don't stop watching Traitors. Because you just don't stop watching Traitors. I love Boston Rob. I love Dolores Catania. Love. And I love, this is not a spoiler because it was in all of the other things, that at the beginning, when Tom Sandoval is talking to the words fail me to talk about how amazing Alan Cummings is. Like words fail me. This is the other AC. Oh my God. Can we have all 3 ACs do New Year's next year? Come on now. I could see it. Cooper, Cummings, and Cohen. Yes, it also sounds like a law firm, but all of it. Can we just do that? All 3 ACs. AC3, please. But anyway, Tom Sandoval is talking about whether or not Cummings asked him, would you feel betrayed if you were not a traitor? And he said, yes. And Alan Cummings is like, isn't a very good feeling, is it? Bitch. He did not say that. I interpreted that from the face. Oh my God, it's so good. Bob the drag queen. Ooh. I love it. I love watching the interplay between the people who played competition reality games or were on competition reality shows like Big Brother, like Survivor, vis-a-vis like the Bravo Lebs who were on different types of reality shows that are seasonal, that are not, they are gamesmanship, but they are different gamesmanship. I love the interplay. I love it so much. So what season is Traitors on? Traitors US is on its 3rd season. Watch all of it. Laura said, wait, Bob the drag queen, you have my attention. Yes. Serving looks. So we're going to stop there. If you do not normally love reality TV, this is how I explain Traitors to my kids who, when they walk by, all of you who love reality TV and have someone in your household that says they don't like reality TV, I don't care what it is, The Bachelor, whatever. All of you have someone in your household that just keeps walking by while you're watching and then eventually sits down and then is invested. This is my children with Traitors. They kept walking by and then my youngest sat down and he's like, explain the game to me. And I was explaining it to him. He goes, so it's almost like Among Us, but with a twist. And it really is almost like Among Us, but with a twist, because those who are not traitors are trying to find the traitors and vote them out. Like Among Us, you're trying to yeet the traitor. But if you get it wrong, you reduce your own numbers. But then the traitors are also getting to vote somebody out as well. So there's like a, survivor type council where they're trying to suss out who the traitor is, like in Among Us. But then the traitors also get to proactively take somebody out. And that is, that dynamic's very interesting because there's gamesmanship to not expose who you are by who you choose to take out. Like somebody calls you out that you're a traitor and then they disappear. It's going to be like, of course. So it's a very interesting game dynamic and I love it. I love it. I just love it. So, if you don't love, it's like Mafia game. Yes, it is. So if you don't love reality, it might be interesting to watch. Xena Warrior, I need to find a way to get us a Peacock sponsorship. I need to get us a way to have like you could probably do a trial actually of Peacock, and then cancel it. So you could probably do a Peacock trial and then cancel it. So wait until this season is done. That's my tip. Wait until this season of Traitors is all aired so you can just binge it and then do like a 7-day free trial and then binge it all at once. That's what I would do if I did not have Peacock. Oh, I didn't know it wasn't available in Canada. Well, that's rude. That's super rude. All right. Donna asked the real questions, and then we're going to get to this ruling. For those of you that are like, I thought we were talking about law, and now we're talking about Traitors. EDB, would you participate in a reality TV show? No, I'd be terrible. No, I'd be terrible. No, I'd be terrible. I don't know how they do it. I talk about this with the people who are on reality that I know. I don't know how they do it. For like a housewife style reality, would I feel comfortable exposing the challenges my kids are going through on a TV show? No. I wouldn't be that open and candid. I would be the one that they're like, she doesn't expose anything about anything. I would just talk about myself. Shocking. But would I talk about what my family is going through if they were going through difficulties? No. Could I do what like Mary is doing this season on Real Housewives of Salt Lake City? I don't think I could. I think it's great that she is. I don't think I could. Would I be interested in a reality like show like Survivor? Also, no, I'd be terrible at it. But I would be more interested in a show like Traitors, like the game show style show, than a Follow My Life style show. A Follow My Lifestyle show would be very boring. A Follow My Lifestyle show most days of the week would be me going, shit, I'm late. Do I have enough coffee? Fascinating. And shopping at Target. and rereading the Fourth Wing series, getting ready for the next book launch and trying to figure out if I'm going to actually try to get to Target in the morning to get the Target limited edition. Like my life is boring. So, but if there was like a social media personality Traitors type situation, yeah, that would be fun. Could I do Amazing Race? No, I get way too motion sick. Way too motion sick. Oh, this is great news. The Knowledge Seeker said Traitors is on Crave in Canada. Oh, that's fantastic. All right. Let us get to, I'm so bummed that I can't just binge watch all of Traitors, by the way. This is where I'm at with Traitors. It's one of the only shows that I want to watch in real time when it drops. I don't want to just wait till the season's done and then watch it at my leisure. It's one of those shows I want to watch as it goes. Miss Mandy said you would be a great host of a reality TV show. That I would do. 100%. Speaking of reality, let's get back to what Judge Cannoni is doing in reality. And for all of you that are not subscribed to Quick Bits yet, look, you'll get this entire segment with all of my diatribes and sidebars cut out. That's what Quick Bits is for. So when we clip this down, you'll get all of the ruling and the road so far and the rest of it. And then none of all this. This is just for y'all that are here live. All right, Judge Cannoni, let's see what happened. Memorandum of Decision and Order on Commonwealth's motion to exclude the testimony of Dr. Marie Russell. Before the court is the Commonwealth's motion to exclude the... I should give you the date. Let me give you the date. I don't want to spoilers. I'm sure some of you already know what the judge did. This is January 13th. So, damn it, Emily. Didn't want to give you spoilers. And then I did. We're going to go through it anyway. Before the court's the Commonwealth's motion to exclude, Dr. Russell intends to testify as to whether the abrasions on John O'Keefe's right arm were caused by a dog. Yes. The Commonwealth contends that the defendant has failed to show that her testimony meets the requirements set forth in Dauber and Lanigan. The court conducted a Dauber-Lanigan hearing on December 12th and January 7th. We know we were there. Although a close question, the court will deny the Commonwealth's motion. What does denied mean? Denied means that Dr. Russell can testify. So denied in this context means she is allowed to testify because the motion to exclude her is denied. Although a close question is interesting to me, because I think when the court is saying it's a close question, the court is referring, well, let's keep reading. Let's keep reading and see if she says why it's a close question, because Dr. Russell is eminently qualified. The question really, for me, broke down to the prong about methodology, and that's different. But it's interesting she said it. So, for those of Allie, I think it's Allie in the chat said, a close question. Nah, she's just mad she can't deny it. She would have to contradict herself to deny this motion, right? Judy, you got this. You are correct. Judy, for anyone asking about the mug, it is listed on Amazon. This was a limited color, but this style mug from Stanley is listed. Look, it does not fit in a cup holder, but if you want to keep your coffee hot, here's the secret. And then we're going to get back into what the judge is doing. Comfort mug. Put hot water in this before you put your coffee in it. Let it heat up, then put your coffee in it. It's going to keep your coffee warm. It is good stuff. But I don't think this is a close question. But let's see why she thinks it's a close question. Before a witness can provide expert testimony, the court, as the gatekeeper, and that's true, that's the language all the case law uses, must make a preliminary determination that the testimony has satisfied the requirements for admissibility. Expert testimony is admissible, and then we're going to go through the law here. I'm going to go through the law here because we talked about these factors, and I'm going to let you know what I think as we go through what the judge thinks. Expert testimony is admissible when the testimony concerns matters beyond the common knowledge of the jurors and will aid the jurors in rendering a decision. It's interesting to me that no one here argued, look, people who have experience with dogs, this is common knowledge. I appreciate that no one made that argument, but I wasn't sure if the Commonwealth would make that argument or not. Like, I could see the Commonwealth trying it, right? And being like, well, I mean, if you have a dog, then what about this? So we will continue on. It goes on to say expert testimony is inadmissible, however, when the witness testifies to matters beyond her area of expertise. Right. I mean, I feel like I do a very good job most of the time of breaking down the law, and my critical thinking skills all go here. If you want me to do a critical thinking book review, like the Jack in the Books here on YouTube or Elise Myers or whatever, you're not going to get that from me. Was I an English major? No. Am I going to talk to you about a book prose? No. Same with movies. What you're going to get from me is, I liked it, I didn't, this is why, and did I cry? Like, that's what you're going to get from me, because my critical thinking all goes here. When it comes to book, enjoyed it or didn't. Enjoyed it or didn't. That's it. Any breakdown of the sentence structure and the story pacing? Nope. Nope. My critical thinking is not used there. It is used here. So there are things I'm definitely not an expert on, and wouldn't be able to testify to them on. Let's see. The determination of admissibility is within the court's discretion. However, before the court may exercise its discretion to admit expert testimony, the party seeking to offer the testimony, here the defendant must establish 5 foundational elements. I'm going to tell you what I think of these. 1, that the expert testimony will assist the trier of fact because the information is beyond the common knowledge of jurors. I think yes. Tell me what you think of prong 1. I think yes. I am someone who has never owned a dog. My family, growing up, did not have dogs. I did not spend, my friends, like, we would hang out in like elementary school and go walk their dogs, but I am not a person who has had a ton of experience with dogs. Cats, more so. Dogs, no. So for me as a juror, I would need that level of expertise. Some of you have a ton of knowledge about dogs, but jurors can't give each other that type. Well, they do anyway, but they can't give themselves that type of knowledge. Like, well, in my experience, this. Do they? Yes. But you're supposed to base it on the evidence. And so would that type of testimony help me? Yes. Remember, the jurors get to decide to give the weight necessary. So if jurors say, but on the cross-examination, I'm not really buying it, that's their right, but the juror gets to decide. So would her testimony assist with a juror because it's information beyond common knowledge? I think yes. That the witness is qualified as an expert in the relevant area of inquiry. I mean, I think this expert's probably an expert in a bunch of areas of inquiry. And I think this area of inquiry is difficult because when you're looking at a treating physician, they probably are in the best position, but they don't have a methodology the same way that maybe you would break down in other things. I think the problem with this particular area is it's almost too basic to have a methodology, because for treating physicians, they look at it and go, that looks like a dog bite. And then somebody goes, yeah, it's a dog bite. And then they're like, yeah, that's a dog bite. It's almost too easy to ascertain for people who regularly see this for it to have a deeper methodology than that. And that's part of the problem here, is that it is almost you know it when you see it, but there are books that talk about it because you've got to teach people to see the first one at some point. Continuing on. The expert's opinion is based on facts or data of a type reasonably relied on by experts to form opinions in the relevant field. I think this is where most of the prosecution's argument should have stayed focused. I think attacking whether or not she's an expert or not was dumb. I think this is where the prosecution could have done a better job and didn't. Do you know the defense in their argument to the court at the end? Alessi made an excellent point. Alessi's point was, look, the prosecution didn't bring in any other doctor to say that this is not relied on in the relevant field. The prosecution didn't bring in anyone to rebut that this is the way that this is done. So the prosecution didn't show that. Could they have? I don't know. Could the prosecution have found a bunch of ER docs that say that's not how we do it? I don't know. Maybe not. So I think that is where Alessi made a very good argument, that the prosecution based their argument on prong 3 on their own supposition. 4, that the theory underlying the opinion is reliable. I mean, doctor says, I've seen thousands of this type of thing, therefore it's this type of thing. I think that's reliable to this doctor, and I don't think it's coroner armpits, which concerns me. I don't think it's I threw my phone around in the office and it lit up when I did this. I don't think it's that. When we're talking about reliable, that one was tough for, I think, everyone. So is it reliable? Thousands. And 5, that the theory is applied to the particular facts of the case in a reliable manner. And that is for the judge to decide. They didn't get into that prong a ton about whether or not, well, I guess they did. They got into the picture. But that's the foundation in Massachusetts. And the court's going to walk through what she thinks. And I've told you what I think. Here, the recognition of dog bite wounds is not within the common knowledge of a lay person and requires expert testimony. Yeah. And Dr. Russell is qualified as an expert on these topics. Yep. 1, 2. She's a board, so this is going on prong 2. She is a board certified emergency medical doctor with over 30 years experience, is trained in forensic pathology, has conducted over 500 autopsies. With respect to dog bites specifically, look, we're still going on about Dr. Russell being the most expert. With respect to dog bites specifically, Dr. Russell has treated hundreds of wounds resulting from dog attacks during her time as emergency room doctor and co-authored peer-reviewed articles on the treatment of law enforcement canine bites in the emergency room. Lastly, informing her opinion on this case, she conducted a differential diagnosis based on the pattern of the victim's wounds and their characteristics and supported her theory with references to peer-reviewed publications. Use of a differential diagnosis. The court said this is the methodology. This is the methodology. Use of a differential diagnosis is a standard scientific technique in identifying the cause of a medical problem. And then case of Hicks, Massachusetts, 2005. I don't know if anyone cited Hicks. They might have, I just don't remember. But the court said, look, the differential diagnosis is the methodology here. This is how doctors go through this process. I think where Dr. Russell struggled is that this is second nature. And so slowing her brain down to explain that second nature identification is difficult. It's like, how do you explain that you recognize your best friend, child, partner, parent? Like, how do you explain something that you recognize the second you listen to it? How do you explain that you know that that first snare snap is from Dave Matthews Band and not somebody else? I don't know how you explain it. It's second nature. It's like you're like, you know. And I think that was difficult for Dr. Russell because she is so knowledgeable. And it was hard to take what is almost second nature all the way back down. I didn't realize how hard this was until talking about how to drive with my teen who is now driving. Like, it's something that's so second nature, and then you try to break it down into steps. It's like, A, this is difficult, and B, I'm going to get car sick. Trish Nichols says, hi, everybody joining from El Segundo. Love El Segundo. Venti ice latte and chocolate croissant. Please stay safe, everyone. Thank you, Trish. Good to see you. And have a slice at Slice and Pint for me. It is the pizza I miss the most. So I think it was difficult for her to explain how you do something that has become second nature, right? And that's on Dr. Russell. She is going to have to figure out how to do that well before the next trial. And I know, especially for people that I think Dr. Russell's brain operates very quickly on a very high level. And everyone knows someone like this who has a hard time bringing it down to everybody. I think she did a good job. I think there's room for her to do that better. So it's like those math professors who could explain like quantum physics to you. And you're like, look, I just need to understand algebra 1. I just need you to explain it. Please. I hated algebra. All the maths. Let us continue. My kids love it. They're like, pattern recognition. I'm like, this isn't words. Leave me out of it. All right, let's continue. Emily, we don't need to talk about your math trauma. No, we don't. So differential diagnosis is how the court laid out what the methodology was here. And I think the court did that well. Emma, you're not the only one in the chat who were thinking of I left my wallet in El Segundo. El Segundo is where we lived before we moved. Jen, thank you so much. I have not been to the P.O. Box, but I do have a stack. So before our next Members Only Live, I will go through the P.O. Box stack. So thank you. Accordingly, they said the court finds that Dr. Russell's testimony satisfies the 5 foundational elements and therefore will allow Dr. Russell to testify as to whether the abrasions on John O'Keefe's right arm were caused by a dog. Period. The fact that there's another paragraph concerns me because that's period. That's the end of the ruling. That's it. That's it. That's the end. These are why the foundational elements have been met. This is why we're allowing it, period. Why are we still talking? Emily, you're the one talking about snare snaps from Carter and how you can identify them by like vibes. I know. The hypocrisy. In so ruling, why are you still talking, Your Honor? Stop typing. Just this is the part you leave in the drafts. Leave it in the drafts. Damn it. For all of you talking about chocolate croissants, don't worry. I've got a sponsor coming up for you. Don't worry. I got something for you, chat. Just wait. In so ruling, the court recognizes on cross-examination the Commonwealth demonstrated, among other things, that Dr. Russell's expertise primarily concerns the treatment, not the identification of dog bites. Ma'am, this really didn't need to come out of your fingers. Also, how do you treat something if you can't identify what the fuck it is? So it's so important, in fact, to the point that there was a whole wasn't that the premise of House? Like, how do you treat something if you can't identify it? Like, chat, raise your hand if somebody's ever identified something wrong and tried to treat it for you, and what a joyful experience that is. Identifying the thing to treat it is like literally the whole point. Ugh. I hate this so much. I hate this so much. All of you who were told it was just ADHD are like, keep peeling those layers. We get to something else, friends. I know. Chat, I know. Cat Mom, yes. One of the mods will link to the Amazon shop. I know all of you have been there. It's so difficult. And for all of you that have been told, like, all the bullshit that you get told, like, oh, you're just stressed. No, it's not that. Ugh. Okay. Oh, this is just call me Hen said hair dye allergy misdiagnosed twice. That's the worst. It took me years for a doctor to identify that I was allergic to chlorine. That's a conversation for another day. But identification is really the primary step in treatment. You identify it wrong and the treatment doesn't always go well. Dr. Russell's expertise primarily concerns the treatment, not the identification of dog bites.
Bruh.
That her evaluation of the abrasions failed to consider all available information, that she has not compared the abrasions with the dentition of the German Shepherd in question.
Bring the jury.
No. Like, just fucking... What? Just... ew, what? Okay, look. First of all, if Dr. Russell, I'm just mad. If Dr. Russell had tried to say these injuries to John O'Keefe's arm came from this specific animal, it would not be admissible. Just like you're not doing dentition bite marks of a human onto a victim and saying these bite marks came to this person's arm. You might be able to say that's a human bite, but you're not going to be able to connect it to the two. Sometimes dental records are used for identification. That's not this circumstance. You're not going to be able to say that bite mark came from that dog. Grateful Edge, yes. For all of you that are like, wait, where did it go? For all of you that are like, you played water polo in the very substance you were allergic to, we'll talk about it. I was sick a lot and nobody identified why I was sick all the time. I was just sick a lot. I was sick a lot and I had a whole lot of other stuff going on that nobody tied back to it. So look, if this doctor tried to say that those bites came from Chloe, that wouldn't be allowed in court. I don't know when the defense had the information that the prosecution went to find Chloe. And a lot of you have asked, how do we know it's Chloe? It's supposedly Chloe. If the prosecution identifies to the defense that this dog is the dog and then it's not the dog, there are bigger fucking problems. Bigger problems. So I know a lot of you are like, I don't trust the Commonwealth for shit. I'm not telling you have to. There are repercussions for that CEG, what we're going to talk about next. But if the prosecution said this was Chloe that was evaluated and provided all the defense and it was not true, there are much larger problems here. So I know a lot of you are like, I don't trust the Commonwealth. Look, question everything. The defense did not go jumping up and down and say this, and that. No RIP Chloe. The prosecution went and evaluated Chloe and took dentition records from Chloe a month or so ago, like November, December. Rando from Iowa, this is my assumption as well, that Chloe the dog was microchipped. That's also my assumption. But Dr. Russell has never said, this dog caused this injury. Dr. Russell has always said, this dog, whatever. Dr. Russell has said, a dog caused this, not a car. Dr. Russell's testimony is those injuries are not from a motor vehicle accident. That's it. Ruling the injury to the arm out. The defense takes it the steps further in building the puzzle of the evidence. A trial is a puzzle, and each piece of evidence is a piece of the puzzle that the defense tries to build to show you the picture on the box at the end. That's it. This is one piece of the testimony. Dr. Russell's trying to say that's from a dog, not a car. Does that mean he was not hit by a car? It means the injuries from the arm aren't from the car. When we get to ARCCA, they say he wasn't hit by a car. That's different. All Dr. Russell said is those injuries are from a dog, not a car. That's it. Not those injuries are from this dog. And the judge going the step farther to say that Dr. Russell didn't evaluate the information from the dog in question. It could be any dog in question. She also didn't say specifically German Shepherd. She said dog, not car. The court has taken it a step further, which is interesting to me. But guess what the fuck Dr. Russell's going to be doing between now and then? Dr. Russell's going to have to look all at the rest of this. I hate this so much, but Dr. Russell's going to have to go through all that the prosecution turned over. I don't think any of this is necessary. All right, where were we before I started ranting? Oh, that she didn't compare the abrasions with the dentition of the German Shepherd in question. Okay. If she does that, is the court going to be able to allow her to say she was attacked by the Albert's dog? Is the court going to allow it? Because I feel like after this, if I'm the defense, I'm like, all right, Your Honor, you want us to talk about the dog in question? You want to talk about the husbands? Then let's talk about the husbands, Your Honor. You want to talk about Chloe? Let's talk about Chloe. Let's bring Chloe into court. I had a judge bring a police dog into court once. It was a very uncomfortable day in court. I'll tell you what, that Malinois sure didn't want to be in court. And the handler was pissed. And the police chief was pissed. There were a few times in my career where I talked to all the way up the chain of command. Oh, and I'm like, yeah, I know you're pissed. But the judge ordered the dog and the dog handler into court. They're like, this is a terrible idea. I'm like, I told the judge it was a terrible idea. The judge ordered the dog and the dog handler into court. And it was a search dog. Search dogs key off of stress hormones. Courtroom's a great place for a dog trained to search for people based on stress. Yeah. The handler was so mad. The handler was so mad. The Malinois was so mad. And the judge was just like, this dog. And I'm like, the fuck do you expect, Your Honor? When I said this was a terrible idea, I told you just to bring the handler into court and ask the handler questions. And the court said, I want to see the dog. This is not a cute poochy pooch. This dog was in court looking like it was ready to rip the judge's face off. It was not great. I'm like, just if you want to know how dogs find people when they are searching for people, question the dog handler who trained the dog. Not the dog. The dog can't answer your questions. The dog can just be pissed. bring the dog to court. Sure, Your Honor. This judge and I did not get along well at all. Stories for another day. She and I regularly butted heads. So, continuing on, I'm waiting for this judge to say, bring the dog. Bring the dog. Just bring the dog to court. Just bring the dog. Not going to go well. All right. The court says Dr. Russell did not compare the abrasions with the dentition of the German Shepherd in question. I don't think she needs to do that to say those injuries are caused by a dog, not a car, but I feel like either the court is missing the point or intentionally throwing shade. I'm going to try to be generous at this point. She's not, the court said her opinion was inconsistent with findings that there was no canine DNA in the area of the victim's clothing near the abrasion. Why did you put this in a ruling? A, that's a jury determination. And B, I don't agree. That doesn't mean it's right. I'm just saying I don't agree. I don't think her opinion is inconsistent with finding that there was no canine DNA in the area of the victim's clothing near the abrasions. Did this judge not watch the trial that we watched? Because in the trial, I think the defense did a good job of, and I think the prosecution also illustrated this in their questioning, that the clothing that John O'Keefe was wearing went through like all the things. And I know that somehow a magical hair like held on to a vehicle or stuck on because of the snow or the salt on the road or whatever, fine. But this shirt was under the snow and then on the floor of an ambulance and then on the floor of an ER and then in the back of a cop car and then on butcher paper and then was handled and examined again and again before it was ever swabbed to potentially be DNA tested. Like the amount of shit that shirt went through doesn't surprise me. So the court finding that the ruling was inconsistent with findings that there was no canine DNA is wild to me. Also, if you really want to test the injuries for DNA, you test the victim. Okay. I just think it's a ridiculous thing to put in a ruling. I don't like this at all. I'm generally more generous with this judge. I am not generous on this. It's absolutely unnecessary. This is legally unnecessary. It goes on to say, however, the court concludes that these issues go to the weight of Dr. Russell's testimony. Right. This is all for a jury to decide. I don't know why it's in your ruling. But at least now we know what the court's thinking, so maybe we're happy with that. These issues go to the weight of the testimony, not the admissibility, and can be addressed during cross-examination. Why? So why is it in here? And the court needed to cite an opinion saying, in evaluating admissibility, a judge does not determine whether to credit the expert's ultimate opinion. Right. So why does it need to be in your order? For this, I think it gives the defense a heads up of where the judge is at. Hannah, this is a fair question. Hannah said, you say unnecessary. Is it inappropriate or improper? No, it's not improper. It's unnecessary, and it's not often done. Judges don't often put this much in their orders. But is it improper? No. The judge can say what she wants to say. It gives the defense a heads up of where the judge is at, and maybe that's what the judge is trying to do. Maybe the judge is saying to the defense, hey, these are the problems I saw. Maybe not. It's wild. Can the defense ask for a new judge? No, they've already tried. And this is not grounds for that at all. It's unusual. I don't love it, and it's unusual. MB said, how can it not be improper? The judge is giving her opinion. This is the judge's order and opinion. This is the judge's opinion. Generally, this going to the weight or the admissibility is kept out. I think the judge getting into this is unnecessary. But I don't think it's improper. It does give the defense a heads up. It also gives the prosecution a heads up of what she's saying. But this all goes to the weight. The court could have said, if she wanted to address it, say, though the prosecution argued this is this. And that's what she said in her way. The court recognizes that on cross-examination, the Commonwealth demonstrated. But her using the word demonstrated, not the Commonwealth argued, is different. The Commonwealth argued this. The court finds those things go to the weight of the testimony, not the admissibility, is a fair way to address the argument from the other side. But she didn't say that that was the argument of the Commonwealth. She said that that's what the Commonwealth demonstrated. So it's an opinion. The defense will glean some information out of it, and so will the prosecution. The prosecution knows, but we'll see. I don't love it. I think there's a way to say these are the Commonwealth's argument, and those go to weight, not admissibility. But the court let everyone know what she was thinking, didn't she? So we'll see. But it gives the defense a good heads up of what Dr. Russell might need to do between now and then. The difficult thing is, if Dr. Russell updates what she reviews, she's going to have to make a report and she's going to have to turn it over, or it's going to be a giant problem. So I don't love it. So Charmander said, I don't know how lawyers keep their blood pressure stable. It's part of the job. It's part of the job, and they like the fight. I don't always like the fight. I'm tired. Tyrone asked, does the ruling mean Dr. Russell can't testify about her opinion regarding wounds from a potential car strike? No, Dr. Russell does get to testify. The ruling denies the Commonwealth's motion to exclude Dr. Russell. Let me put that back up. So, for the foregoing reasons, the Commonwealth's motion to exclude is denied. So Dr. Russell will testify. The court gave a little bit of I think the prosecution showed these things, and these things go to weight. So, that. All right. Don't love it, but okay. I keep doing that. That's on me. Like, that's operator error. I think real quick, because, we're already an hour in. We're going to need to switch to Baldwin really soon. We're going to go to one more document real quick. Let me pull it up because I didn't pull it up earlier. So I'm going to have to, I didn't link it in my notes. So I'm going to have to go grab it real quick. A number of you asked me on the 7th about Brennan's motion regarding the crash daddies. So let me pull that up real quick because I think it was confusing. And I said, I'm not covering this in real time because we're in the middle of live court. And there are very, very, very limited circumstances if we're in a live court day that we're covering anything else. Especially in this case, because stuff gets harder to find. And I wanted to make sure I had the entirety of it. But the Commonwealth has made multiple motions. The Commonwealth has made motions with regard to the digital expert. We know that we'll be back in court on the 31st for that. So when I get to the summary of this, we'll talk about being back in court at the end of the month. But I want to pull up that motion from the prosecution, from the Commonwealth, just to take a look at real quick because there were some questions about it. And let me do this real. No, there we go. Make it easier to open. Me yelling at Google Drive. All right. Let's take a look at this. This is from January 7th because this was contemporaneous with us being in court. Actually, I think that's a little easier. With us being in court on the Dauber-Lanigan hearing. It's not your eyes. It's not your screen. It is a little bit fuzzy based on the way that the motion was scanned. These Massachusetts. Notice of Commonwealth's intention to exclude ARCCA witness Daniel Wolf and Andrew Rentschler, I think is how he pronounced it, for I don't know what that says. Inability to comply, expected inability to comply with Rule 14 discovery obligations. This is the strangest motion to me. Expected inability, like we have foreseen, maybe he called the TikTok psychic. We have foreseen that no one can comply with the discovery obligations. We've just seen it. We just know. What? Now comes the Commonwealth and respectfully provides notice to the defense and this honorable court that at some point prior to trial, great, it expects to move to preclude the ARCCA witnesses, the crash daddies. These are the biomechanical engineers that were hired, just for everyone who needs the road so far. These are the biomechanical engineers that were hired as part of the federal investigation in this case. There was a substantial grand jury process. We don't know what has happened. We have not seen that the grand jury has made any final determination. We don't know if the grand jury is still ongoing. We know that there was a grand jury. We know that the FBI hired these experts along with the U.S. Attorney's Office to look into this case. These experts evaluated this case and determined that the injuries caused to John O'Keefe did not come from a vehicle collision. They are, I thought, eminently well qualified. They're very interesting. They have quite an extensive background, and they are biomechanical engineers. This is what they do, which is why we called them the crash daddies. When you look at biomechanical engineering, I think the only trial other than Karen Reed that we've gone into that extensively was the ski crash collision in the Gwyneth Paltrow case, where there were biomechanical engineers to talk about the mechanism of crash and whether or not, you get blown from behind and still keep your skis on. Yes, a lawyer said that in court. I wasn't making that quote up. I stole it from Owens, but it was very interesting. The biomechanical engineers and the battle of the biomechanical engineers came in on how could this have happened? And that's what they were doing here. Looking at everything we have, how could this have happened? And the prosecution said they might ask to exclude these witnesses, not under a Daubert hearing, not under they're not experts, not under there's no methodology. This is under discovery rules. They say that as proponents of the witnesses, it is incumbent upon the proponent, the defense, to comply with Rule 14 discovery obligations. The obligation is not dependent upon best efforts or fault. Rather, it's simply the obligation of the proponent of the witness to comply. The defense must comply, they're saying. The history and complexity of the ARCCA witnesses' employment and directives are muddled and unnecessary to recount for the purpose of this notice. Rather, it is expected that if the defense attempts to proffer either or both potential witnesses, it will be unable to comply with Rule 14 obligations. These witnesses were allowed to testify at the last trial, and there was a fairly substantial day of voir dire or questioning with the attorneys to allow all that information to come in. And the defense is like, we've got the information we've got. And the prosecution's like, well, we've got the information we've got. And the court said, fine, I will let it in. And we're going to do it with a voir dire. So if the court had wanted to block these witnesses then, the court could have said to the defense, you have not turned over sufficient information. The defense didn't have that information. I don't think that they did. I don't think they had substantial information from the feds, and some of it is probably privileged under the grand jury, which is going to cause a problem. But if the court had wanted to keep these witnesses out, I think there were grounds for her to do that. So the court allowing these witnesses in was a balance. I don't think the court's going to change their mind now because the court allowed it in. And the court at the previous trial said, we'll do a voir dire and that's fine. So I think we might see another voir dire of these witnesses or the defense being able to have more communication with these witnesses? We'll see. But I think that the prosecution's not going to get very far with this. They go on to say the Commonwealth does not allege that the defense will be negligent or unwilling to comply. Rather, it's expected that given the handling and employment of these witnesses, the defense will simply be unable to meet its obligations. They suspect that when they ask for discovery, the defense won't be able to give them anything, so they're on notice. The Commonwealth provides this notice prior to any hearing or filing of a motion to preclude and prior to a ruling on docket 442, Commonwealth's motion for reciprocal discovery pertaining to ARCCA. So there is a discovery motion pending. The Commonwealth has said, we don't think you'll be able to comply with it because these are your witnesses, but they're not like your witnesses. You didn't hire them. So we're going to make this motion and everyone's on notice. The purpose of notice is to alert the defense and the court of the Commonwealth expected position given the trial date and the impact exclusion would have upon the defense. Your Honor, you haven't ruled on our discovery motion yet. The defense hasn't failed to turn anything over, but we don't think they're going to be able to. So we're going to ask to exclude these witnesses. Just a heads up. The prosecution knows what these witnesses are going to say because they testified at trial and at a voir dire hearing. They testified twice. So I don't think the court's going to change course on this one either, but I think it's going to be a fight. So we'll see. Let's try to summarize this and then let's go talk about Baldwin, shall we? Who's here to talk about Baldwin? Let me know if you're just waiting to talk about Baldwin. Let's do a summary of this. Going through some of the pending motions and the court order in the Karen Reed case, we learned that Trooper Proctor is going before the full disciplinary trial on January 15th, 2025, and that permanent discipline, I read that as potential firing, is on the table. Trooper Proctor was the lead investigator or the case investigator on the Karen Reed trial. His text messages came out in the trial. They have asked for even more information from him while this has been wandering through. How this will impact the retrial is going to be very interesting because there are some foundational things that Trooper Proctor did with regard to evidence in the case that he alone did. So if he is terminated, how does that make him look at a witness? And can, as a witness, he look any worse than he did in the first trial? We'll see, but we should have information about what happens with Trooper Proctor soon. And based on the disclosure filed to the court, we know that after the disciplinary action is completed, that everything from that disciplinary action and the hearing and the disciplinary trial will go to the defense. So if anything, the defense will have even more information ahead of the second trial. We also covered the fact that the Commonwealth put the defense on notice that they may seek to exclude the accident reconstruction biomechanical engineers that testified from ARCCA. That is an abbreviation for their company. These are the experts that testified in the defense case in chief that weren't hired by Karen Reed's defense team. They were brought in as part of the federal investigation of this case and then testified about their findings. The biomechanical engineers determined that John O'Keefe's injuries were not consistent with a vehicle collision in any fashion. And they had some of the clearest testimony in the first trial. And I imagine that testimony was incredibly persuasive to the jury, as it was incredibly persuasive to anyone, I think, watching the trial. They were good witnesses with a substantial amount of expertise and weren't hired by either party involved in the underlying trial, which is a very unique circumstance. The fact that that testimony came in the first trial and then the Commonwealth is pursuing a second trial on all the same charges is still a bit wild to me. Then we went through the court's order with regard to Dr. Russell. Dr. Russell testified at a 2-day hearing to determine whether she would be able to be an expert witness or not regarding the injuries to John O'Keefe's arm. Did they come from the vehicle collision or did they come from a dog? Her testimony consistently has been that those injuries are more consistent with a dog than they are with a car. The court is going to allow Dr. Russell to testify, but definitely put a bit of an asterisk in her ruling saying that it's noted that Dr. Russell did not compare the dentition of the dog in question to the injuries. So I imagine we're going to see another report from Dr. Russell now that the court said, well, you need to consider the dog in question. Dr. Russell never testified that a specific dog caused the injury to John O'Keefe, just that it was a dog, not a car. And so the court bringing that up was interesting to me, but I think we're going to see more about the Chloe of it all as this case moves towards trial, because the prosecution said, and we heard for the first time, that they went and found Chloe, wherever Chloe is in Vermont, and took molds of Chloe's teeth and measured Chloe's paws and claws and the rest of it. So we're going to learn more about Chloe as we continue moving through trial. But for now, Dr. Russell will be allowed to testify. Dr. Russell will be allowed to testify that this was from a dog, not a vehicle. And the court put a note in there that I think is going to warrant Dr. Russell going back through more information and submitting a supplemental report. I think that's going to be the result. All right, chat, let's talk. You ready to talk about Baldwin? Let's talk about Baldwin. I know. Are they going to bring Chloe into the court? B2 said, well, I have a lot of questions about Chloe. I mean, same. How did they? Same. I have lots of questions. Oh my God, this jelly bean in the chat with the scandal reference. Chloe is in Vermont making jam with the former president. I mean, making jam sounds onerous, but yes. Everybody's ready to talk about Baldwin. Are we ready? Let's move on. Alley Cat asked a question. I answered it a bit earlier. I'm going to answer it again because I think you echo a lot of sentiment in chat. And I stream for a long time, so people come in and out. Look, are we sure the prosecution's trustworthy that it was really Chloe? The defense did not jump up and down like frogs were coming out of their head saying this isn't Chloe. I imagine that whatever report the defense has makes clear how they connected this dog to that dog. And if the defense believes that there is fuckery afoot, do you think this defense team is going to keep it quiet? I don't think so either. If the defense thinks there is fuckery afoot, they will let us know. Angie is having kimbap for lunch. Yum. So we will see. Can Dr. B examine Chloe? No. Dr. B is not a veterinary dentist, but could Dr. Russell go examine Chloe? Dr. Russell's like, I don't need to. I'm not trying to tell you this dog did this thing. Dr. Russell's like, I'm telling you a dog did this thing, not a car. That's it. Wild. Just wild. So we'll see. All right. Let me pull up the ruling from Baldwin. Just a warning. Just a little bit here. I'm going to turn this down. Just a little bit of a warning. This is a 73-page filing. Are we going to go through every single sentence of every single page? No. Do I owe all of you in the Law Nerd Lounge some of these documents? Yes, I will add this one to it. Are we going to go through every single line of all 73 pages? No. We'll be here another 3 hours. Are we going to go through the high points? Yes. Do we know a lot of this already? Yes. Have I read the entire thing? No, we've skimmed it. But I did skim it because I covered it in quick bits. So do we know what they're talking about? Yes. How did we get here? Well, that didn't work right. There we go. The motion is going to lay out some of the procedural history. So I'm going to try to do the quickest road so far summary I can of why we are talking about Alec Baldwin again in connection to the Rust hearing. It's because he is suing all of the prosecutors and more. Alec Baldwin is suing for not only essentially malicious prosecution, but spoliation of evidence, but also defamation. Baldwin's pissed. This all comes on the tail of Kari Morrissey, the appeal that she was pursuing. So the first thing we're going to look at is the withdrawal of the appeal and then we're going to look at Baldwin's filing. This is all still coming out of the Rust prosecution. Many of you watched it with me on day 3 of the Alec Baldwin trial in Santa Fe, New Mexico. Day 2, at the end of the day, I sat there and went, wow, the defense had a bad day. End of day 2, defense had a bad day in court. Defense seemingly misunderstood one of the court's rulings and said, wait a second, we didn't think the prosecution was going to be allowed to use all of this information in his interviews. We didn't think the prosecution would use all of this. We understood they would only use these things. So the end of day 2, the defense had a terrible day in that they weren't clear on the court's ruling. How they weren't clear is still confusing to me because A, if you looked at Hannah Gutierrez-Reed's trial, the court let in every single statement Hannah made. And B, it was clear to everybody that what was going to be strongest for the prosecution was to use Baldwin's words against him. So I think all of us just expected that. But the defense was seemingly a little bit shaken. And Spiro said in court, I would have done a completely different opening statement if I knew that this is what the court meant. That's not a good place to be when you're the defense. So when we started day 3 of the Baldwin trial and the defense was making all of the wild gesticulations in court about the fact that the prosecution had hid evidence and the rest of it, I was like, well, after their day yesterday, they're going to have to do quite a lot to undo the damage that it seems they think has been done with not understanding what the court was allowing in. I think I might have said at some point, the defense is going to throw everything at the wall and see what sticks here because they had a terrible day yesterday. And we know that the trial that they thought they were getting and what's actually happening are not necessarily the same. And then midway through day 3, we all went, oh, the prosecution did what? And then it got worse and worse and worse for the prosecution. And then the case got dismissed. I don't think I've seen a swing like that in a case ever, where it's gone from the defense saying, I would have completely done this case differently if I had understood the court's ruling to mean that, to the case being dismissed. So now we are after Kari Morrissey, the prosecutor, tried to appeal the dismissal multiple ways. She appealed it first to Judge Summer and then filed notice of appeal to the Court of Appeal. She just withdrew that, so we're going to take a look at that. But then we're going to look at Baldwin suing. Just absolutely, this case has been wild. But at the end of the day, Judge Summer dismissed the case against Alec Baldwin because of the prosecution's actions/inactions. Not because there wasn't evidence against Baldwin, not because the case shouldn't still go forward, because of the prosecution's actions. The case being dismissed was a sanction against the prosecution for not turning over evidence. That is why the court did what they did. Is it an extreme sanction? Yes. Is it often that that's what the court chooses to do in a discovery violation like that? No. But because this had been a consistent problem in this case, which the court lined out in their ruling, the court felt that this was the only way to protect the defendant's rights. And for all of you that do not like Alec Baldwin, I get it. I get it. Take Baldwin out of this and just try to go with defendant. Try to get to defendant who is not Baldwin and take a look at this with a step back. Because not liking someone is one thing, but thinking it's okay for the state to just go forward with all of this fuckery afoot is a whole different thing. And sometimes the checks on the state come in a package that maybe some people don't like. Does it mean that and I've seen a lot of these comments that Baldwin just gets away with everything. Baldwin does this, Baldwin does that. It's not really about him. It's about the prosecution. The point is that the prosecution doesn't get away with trampling over people's rights. It doesn't matter how liked those people are. So if your rights are violated, I don't really care how popular you are on the internet. It's still fucked. So that's where we're at with this. But does it mean that Baldwin's not getting prosecuted anymore? Yes. Is that because of Baldwin's action? No. It's because of the prosecution's action. And we cannot have prosecutors that just run wild and everybody goes, yeah, I don't like that person, so fuck them, it's fine. It is supposed to be a neutral level where who the defendant is not really the point when we're looking at the actions the prosecution took. It shouldn't be, yeah, but it's fine because I don't like them. That's not how it works. So it is easier when the defendants are sympathetic. When the defendants are not sympathetic, there's a lot of, yeah, but fuck that guy. Look, I understand. But this is really about the prosecution. And Baldwin has enough money to hire the lawyers that are going to keep going on this. Would we see this kind of filing in other cases? Maybe, maybe not. But rights should apply to everyone equally. And I think it is fair to keep fighting for rights applying to everyone equally. It's like evaluating free speech. It's really easy to evaluate free speech when it's speech that you like. It's really difficult when it's speech that you don't like. And it is harder to stand on principle when you don't like the result, you don't like the person, or you don't like the thing. So for me, I'm here. I think it's Silja. If I didn't pronounce it correctly, I apologize. Silja the Knitting Baker. I'm disappointed in the prosecution for not doing their job properly. Yes, that's who gets the smoke. The smoke goes to the prosecution in this. So, if they had done their job, I think Baldwin would have been prosecuted on the evidence that they had, or convicted on the evidence they had, based on his own words. So that's what I think. I think that could have happened. But we're not going to know because the prosecution went for fuckery. So no fuckery. We hate the fuckery. None of the fuckery. And it is hard to talk about those principles when it feels unfair that Baldwin will not be criminally punished for what happened on the set of Rust. I understand. Violating his rights is more unfair. That's just the way our system is set up when it comes to constitutional rights, and the violation of the rights will not stand. And if the prosecution hadn't had other issues, I don't think the court would have dismissed it here. If the prosecution had not had any other issues, if this truly was a oh shit mistake, I could see the court calling it a mistrial and giving everyone more time. And that's often what would happen. But I think because there had been so many other issues, particularly with discovery, particularly with Brady discovery, because of that, I think that's why the remedy in this case was so strong, because this had happened over and over and over again. And the court believes, based on the court's ruling, and if you haven't watched that video, I have a whole breakdown of the court's ruling. The court believed that people lied in court. And when you get to there, it gets worse. I think Kari Morrissey made this worse for herself by quadrupling down. So with all of that, let's look first at Kari Morrissey's withdrawal of appeal. This came in right before Christmas. Let's see. So let me grab that link. This was filed on December 23rd. What was I doing on December 23rd? Making cookies. Why? Because I got a new KitchenAid mixer and it's beautiful and it makes it fun to do shit in my kitchen. The baker got to be a baker, but was I covering this on the 23rd? No. Was I tempted to? Yes. Was it hard to be on break when so much shit was happening? Yes. What did I do? Watched movies with the family and made cookies, because sometimes it is hard to be on break. But if you don't put your foot down, then there will never be a break. I will never take a break if I'm like, yeah, well, we might as well. I literally took apart my entire office so that I could not stream. It is the one with the wooden bowl. It is the one with the wooden bowl. When I saw it, I gasped. And my 16-year-old was like, my 16-year-old looked at me with like, what age do you become when a kitchen appliance is this exciting to you? Like, that was my 16-year-old. What age are you when a literal kitchen appliance makes you go, oh my God, that's gorgeous. I don't know what age that is. I don't know what age that is, but I'm here for it. It's the same age when I started getting into bird feeders. I don't know. Somewhere for me after 30, I think your use may vary. However, every time my 16-year-old gasps when he sees like a Supra on the road, I look at him and I'm like, same. It's a car. I don't know what the difference is. Your excitement over a Supra is the same as my excitement over my mixer, sir. Also, you are not driving that car. It is way too fast for a 16-year-old, and no one can afford the insurance for that shit. So, gasped. It's the little things that make life exciting, right? Back in the day when my husband and I would be like, we got to go run errands. Should we also just like go through Bed Bath & Beyond and see if there's any cool new shit for our kitchen? Yes. Yes, we should. All right. Let's look at Kari Morrissey giving up the fight here. There we go. All right. Kari Morrissey, what have you done? December 23rd, 2024, notice of withdrawal of appeal. The state of New Mexico, through Special Prosecutor Kari T. Morrissey, hereby notifies the court and the defendant of the withdrawal of the notice of appeal filed on November 21st, 2024, and states as follows. I mean, you could just withdraw, right? On October 21st, 2021, Helena Hutchins was killed when a .45 caliber revolver believed to be loaded with dummy rounds was discharged by Alec Baldwin. Both Hannah Gutierrez and Baldwin were ultimately charged with involuntary manslaughter for the death of Helena Hutchins. The charges against Baldwin were pursued after discovery of significant evidence that Mr. Baldwin violated numerous gun safety rules established for the safe handling of firearms on movie sets. 6 rounds of live ammunition were found on the movie set, and all had Starline brass casings and nickel primers. Oh, she's not done arguing. Ma'am, this was dismissed with prejudice. I still don't know the legal grounds for anyone to undo that. Like, jeopardy attached? Like, I still don't know how you legally, like, there is no lawful law. Like, in this one, Brooks would have been right. What's the lawful law? I don't know. Jeopardy attached, it was dismissed with prejudice. An appeal can't undo that. Jeopardy attached. You can't retry him. Like, what the fuck are you going to do with your appeal? I need someone smarter than me to explain it to me how there's law to do this. Because what's the result of the appeal? Even if you're right, you lose. Jeopardy attached. Double jeopardy's a thing. This wasn't a mistrial. It was dismissed. You can't undismiss it. This is the literal example of you can't put the shit back in the horse. It's out. You can't unring the bell. You can't put the tooth back in the toothpaste, or the toothpaste back in the tube, whatever. Don't put your teeth in the toothpaste. Like, what are you going to fucking do? But she's not done. Instead of just saying we are withdrawing the appeal, it's again with the, but we were right though. Stop it.
Bruh.
She is just going to continue to try to relitigate this. Ma'am, you're done. It's done. It's done. Don't make me pull Heather Dubrow onto this soundboard with, when everyone says you're done. Maybe it's time to lay down and die. That's not an exact quote. It's close, though. But no, we're going to relitigate what the facts are and Troy fucking Teskey one more time. 6 rounds of live ammunition were found on the movie set and all had Starline brass casings and nickel primers. In November 2021, Troy Teskey notified Seth Kinney that none of the ammunition in his possession belonged to Thel Reed had nickel primers. On November 2nd, 2023, Teskey notified undersigned counsel that he and Thel had shot most, if not all, of Mr. Reed's ammunition that was in his possession. Mr. Teskey was unclear if he was in possession of any remaining ammunition belonging to Thel Reed. On October 6th, 2023, was it really October? It was like 100 years ago. On October 6, 2023, Judge Summer upheld a request by Rust Productions, LLC, that all video from filming of the movie be provided pursuant a protective order. Okay. This rule ensured that the public would have limited access to video evidence from the set of Rust that demonstrated Baldwin's reckless conduct with firearms. Why is that in here? Why do we need this in here? On January 19th, 2020, is that anything other than shade? Ensuring the public would have limited access to the video evidence from the set of Rust that demonstrated Baldwin's reckless conduct with firearms. The civil attorneys are all like, thanks, Morrissey. Civil attorneys in all of the civil lawsuits are like, can we get that? Can we get that footage? Because all the civil lawsuits are ongoing, or many of the civil lawsuits, I should say, are ongoing. On January 19th, 2024, a grand jury made up of citizens from the 1st District of New Mexico returned an indictment against Baldwin for 2 counts of involuntary manslaughter in the alternative. On March 6th, the same day that Hannah Gutierrez was convicted, Troy Teskey turned over 23 rounds of ammunition to the Santa Fe County Sheriff's Department. 3 of the rounds had the same characteristics as the live rounds found on the movie set of Rust. Yup. And you said they didn't. None of the ammunition turned over by Troy Teskey was present on the set of Rust or even in the state of New Mexico prior to Miss Hutchins' death. We have continued to miss the point. We have continued to not see the point the judge is making. I get it, but at this point, I got to turn on my heater real quick because it is getting cold in my office. Look, you and the judge don't see this the same way. The judge said, I don't care that this might not have ever been in New Mexico. That's for evidence. You still have to turn it over to the defense. Here's the thing. You turn it over to the defense first, and then you argue to keep it out. That's how that works. You don't get to decide. She's just like an ex that wants to keep relitigating the same argument over and over and over again. She said the ammunition wasn't in New Mexico. Great. Turn it over, argue to keep it out. Detective Hancock with the Santa Fe County Sheriff's Department made several attempts to interview Mr. Teskey and determine the relevance and materiality of the ammunition. It was put under a separate case number. So we also saw the body cam footage. .45 caliber ammunition possessing the same characteristics as the 3 rounds provided by Troy Teskey to the Santa Fe County Sheriff's Department are regularly available for purchase at retail stores that sell ammunition. This is for motions. ARCCA, bring in the bring it on. I said burr. I can't stomp my feet and clap because my toe. Your Honor, just a reminder, this ammunition could have actually come from anywhere. Fine, turn it over to the defense and argue it's not relevant. It's so not relevant that it got the whole case dismissed. Personnel of the Santa Fe County Sheriff's Department were aware that 3 of the rounds of ammunition provided by Teskey on March 6 had the same characteristics as the live rounds found on the set of Rust. Just a reminder, if the Sheriff's Department is aware, it means the prosecution is aware. Even if they're not actually aware. If they don't know, like, Scotty didn't know. If they don't know, it doesn't matter. It is a prosecution team. And what the cops know, you know. It's your job to know. It's your ethical duty to know. It's your obligation to know. And you not knowing doesn't matter. You not actually knowing is irrelevant to the court. If law enforcement know, you knew. Is that a lot? Yes, it is. Does that mean you have to double check that when your officers are like, no, we don't have anything else, that they're accurate? Yes. Does this result in prosecutors going to the police departments and being like, bring me everything you have, we're looking through it together? Yeah, because that's your job. You've got the one job. That's the job. Turning over evidence is like a critical, foundational part of the job. You had one job. Good Lord. I can't believe we're still going on. None of this is relevant, by the way, to the appeal being withdrawn. None of it. None of it's relevant. I'm so glad I didn't just tell you. I didn't read this in advance. This was for us to do together. I'm so glad I didn't just tell you the appeal was withdrawn and we just went through this. Friendly Farm Girl said, Clovers, my bad. I thought it was the Toros, right? Because the Toros stole all those routines from the Clovers. Exactly. It's exactly right. Friendly Farm Girl, that's the whole point. Why don't they still make teen movies like in the 90s? They were so good. Can't hardly wait. Why? Why don't we have more? Super bad. Like where are they? All right. I don't know why we're still doing this. Personnel of the Santa Fe County Sheriff's Department were aware. That means prosecution's aware. No one from the Santa Fe County Sheriff's Department notified undersigned counsel. Too fucking bad. Also, that's not what Hancock testified to, by the way. No one notified undersigned counsel or anyone on the prosecution team of the characteristics of the 3 rounds at any time prior to July 12th. Irrelevant. 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 As a result, the ammunition was never disclosed to the defense. Look, whether Kari Morrissey knew or didn't know is completely irrelevant. If law enforcement knows, she knows. And I haven't rewatched Superbad. I haven't watched Superbad in a million years. The 80s teen movies too, yes. I just think they could make movies now. That's all. Maybe they're just all on streaming and I'm busy watching Traitors. So Kari Morrissey's argument that she didn't know, you can all say it with me again, is irrelevant because it's irrelevant. She's presumed to know that is the job. And it is also on law enforcement to make sure she knows. But who do you believe in this situation? For those of you that watch this with me, Hancock said Morrissey was part of the conversation. Morrissey said she wasn't. If Morrissey was part of the conversation and forgot, it's the same as if she never knew. It's the same as if she actually knew. Well, no, if she actually knew and lied about it, it's worse. 10 Things I Hate About You is top tier. The Cutting Edge is also top tier. I haven't watched that in forever. Linda D said this is the deja vu no one asked for. Anyone had the same argument with somebody over and over and over and over and over and over and over ad nauseum? It's giving Sarah Boone at this point. Like if she says, but it wasn't intentional, at some point I'm going to scream. No, the goat will scream. Oh my God. And because it wasn't disclosed to the prosecutor, it wasn't disclosed to the defense, this is the job of the prosecution team and the law enforcement. It is it's your job. Doesn't matter. Can you imagine a dentist being like, oh, I didn't know that nobody gave that person anesthesia. Yeah, no, that's not, oops. It's not how it works. Also, sorry for any of you that are dental sensitive. That's probably not a nightmare fuel analogy. On April 15th, Judge Summers sentenced Hannah Gutierrez after the conviction for involuntary manslaughter and stated, "You and you alone stood between a safe weapon and a lethal weapon. This statement was made after the indictment of Baldwin by a grand jury and after Judge Summer. You're going after the judge again? Girl. That's what you want to do? That's what you want to do. You want to go after the judge again? Do we think that's going to go well? Because it's given no. Oh, boy. You and you alone stood between a safe weapon and a lethal weapon. This statement was made after the indictment of Mr. Baldwin by grand jury and after Judge Summer was assigned to preside over the criminal case against Mr. Baldwin. The statement made by Judge Summer was made with full knowledge that Baldwin was also charged for using the firearm in a lethal manner. It's different. Kari, what the fuck? They have different jobs. I don't disagree with the judge here. Chat, let me know. It was the job of the armorer to check the weapon. Baldwin could have been dicking around with the firearms on set all the livelong day, which from some of the video, it seems that he was. And you're not going to end up where we're at if the armorer does their job. If there were completely inert rounds in the gun, it doesn't matter if he's clicking the trigger. That's not technically the right term, but it doesn't matter if he's pulling the trigger and cocking the hammer and full cocked and half cocked and all cocked and no cocked or whatever. It doesn't matter if the armorer does their job. Now, when the armorer doesn't do their job and then Baldwin doesn't do their job, that's different. But Baldwin can be convicted based on pointing a weapon at someone and cocking the hammer and pulling the trigger if the jury finds that that violates the gun safety laws in New Mexico. That's different, because had he done that and the armorer did their job, then there's no impact. There's no fatality. There's no death. There's just Baldwin being a jackass on set and potentially causing problems if there were blanks in there and he was firing when he shouldn't be with blanks that could scare horses on set, that could injure someone, that could damage the ears of the crew. There's other things that could happen. But it is very unlikely that if the armorer is doing their job, this way someone causes an injury on set. Now, Baldwin firing off blanks, could that cause injury on set in a myriad of ways? Yes. Horses being one of those ways. But yeah, the job of the armorer is to stand between a safe weapon and a lethal weapon. I agree. The weapon's not lethal in the way it was on this set if she checks the fucking ammo, Kari. I'm waiting. One of these days, I feel like I'm just going to get an email from Morrissey with timestamps. Other lawyers have done this. We're not going to get into it now, but with timestamps of what I said with their arguments back. At some point, it's going to be but. No. Going after the judge again. I've dismissed my appeal, but I'm still not wrong. You are, though. On June 26, Judge Summer denied the state's request to compel the testimony of Hannah Gutierrez at the trial of Alec Baldwin. This ruling limited the state's ability to present all inculpatory evidence related to Baldwin's conduct. Okay. Is this real life? On July 12th, Judge Summer dismissed the criminal charge against Baldwin with prejudice after determining that the ammunition provided by Teskey to the Santa Fe Sheriff's Department was material and potentially exculpatory. The court also found that the late disclosure of the evidence, the third day of trial, negatively affected the defendant's preparation for trial. Ugh. So, Sarah Boone's left kidney. We'll go through it another day, maybe in a members only live. It has happened where I've talked about cases and gotten the extensive emails of the retorts to what I've said. I keep those private because it's fascinating. We'll talk about what case that happened in. We've got a lot to talk about on members only this month. We're going to have multiple members only this month. Don't worry. Judge Summer dismissed the criminal case against Baldwin with prejudice, determining the ammunition. Go watch my video covering the court's order. The court's order was so incredibly thorough. It was so incredibly thorough. Also, New Mexico puts all their high-profile cases on their website for free. If you want to go read the order and don't have me read it, go for it. The judge was incredibly thorough. And you can just watch day 3. We timestamped it where the judge made this ruling. This judge was incredibly thoughtful and thorough in this and did not take this lightly. I think the judge was pissed that she was put in this position. If I was the judge, I would have been outraged at the prosecution. She did a way better job. Whenever anyone says Emily would be a great judge, on TV only, because the way Judge Summer kept a straight face, like you could tell she was pissed by her tonality and then by her writing, but her being able to stay composed was just, whoa. It was lovely. The state contends that the ammunition was not material to the case against again. We're done with this. It wasn't intentional. We were on a break. Like, stop it. The harping on this again and again. I'm losing my mind. I was wondering why this was 5 pages when it could just be we're withdrawing our appeal. Like, notice to withdraw your appeal is literally this part. Like, no one needs the and states as follows. This is just, I'm not done talking. Spiro's going to have the last word anyway at this point. We'll get to that next. Oh my God, ma'am. The state contends that the ammunition was not material, we know, because it was unconnected to the reckless manner in which he handled his firearm at the time of the shooting. Fucking hell. The state further contends that the defense knew about the ammunition well in advance of trial, a fact the defense has not disputed or acknowledged, and therefore was not disadvantaged by the late disclosure. It doesn't matter. It wasn't disclosed by you. Unless somebody's going to give me some case law that changes that fundamental underlying principle of disclosure, I maintain that it doesn't matter. Disclosure by you. It doesn't matter if Teskey talked to Spiro. It doesn't matter if Bowles, Hannah's lawyer, talked to Spiro and told him, heads up, this, that. Doesn't matter. You have to disclose it. And Kari should have known because she saw the filing. Don't make me make a fucking analogy to Titanic again. She saw the filing that said that there was a mutual defense agreement allowing the defense attorneys to share information. You were on notice that what Bowles knew, he was going to tell Spiro. You know that. Of course. Laura JV in the chat says, I can't believe we're still talking about this. Same. Goldie said, what's the point of her going on and on ad infinitum if she's withdrawing? Personal opinion? Speculation? Isn't done having the last word? It seems to me that Kari Morrissey is stuck in a boot loop of, but you don't understand, but you don't understand, but you don't understand. Just like we saw Sarah Boone stuck in a boot loop of, but it wasn't intentional. Okay, well, it's a second degree. So reckless. But it wasn't intentional. But it wasn't intentional. But it wasn't intentional. Okay. Kari Morrissey's stuck with, you don't understand, you don't understand, you don't understand, you don't understand. I get it. I think a lot of us have been there at some point in our life going, no, but you're not understanding me. The problem is when you're in court, there needs to be an end. We've reached that end, and that ship has sailed. So Kari wants everyone to see it the way she sees it, but has not helped any of us see it the way she sees it. I don't know how we got here. I love this. During an on-record sidebar on July 12, 2024, a special prosecutor requested the court determine when the defense team became aware of the existence of ammunition, as this information was critical to the court's analysis. No, that information is privileged. And Kari, as a defense attorney, should know that. The court declined to make an inquiry concerning the defense attorney's awareness of the ammunition prior to trial because it's privileged. It's either work product or it's attorney-client. It's still privileged. Emma Mack in the chat said it's giving Judge Glanville. Yeah, but who snitched though? Tell me who told you. It is giving Judge Glanville. Tell me who told you. Steele would never. The court declined to make an inquiry concerning the defense attorney's awareness of the ammunition prior to trial. Despite evidence that the defense team was aware of the ammunition in question and its similarity to the live rounds from the set of arrest well in advance of trial. I think that's a stretch. I think this is my speculation. This is my speculation only. From what we saw on the record, I think the defense was aware that Troy Teske went to the police department. I think the defense was aware that Troy Teske turned over ammunition. But I don't think they knew what that ammunition looked like because it was never turned over to them. I don't think they knew what was in the envelope. I don't think they knew there was body cam. I don't think they knew any of that. I think they knew there was a report. I think it's likely that they knew that there was a report. But I don't think the report illuminates everything that came out in court because even the report was pretty short. And even that report was turned over late to Bowles. This was a great question in the chat. DeBeast Mama Bear said, why is that information privileged? This is a great question. I'm sure lots in the chat have it, which is why I love that you guys ask questions. If the defense attorney, and this is a defense attorneys in the chat, and paralegals, this is a simplification. But if the defense attorneys learn that information from their client, it is attorney-client privilege. If they learned that in their work to defend their client from any other source, that is their work product. If they are not using it in their case, they do not have to turn it over. There are some things the defense doesn't have to turn over at all. The defense strategy and how they learned information is not something they have to turn over. If there's a witness they're going to call, they have to turn it over. I don't think the defense ever intended to call Troy Teske, but I think the defense knew enough to pull that thread in testimony. And if they were given that information from either Troy Teske himself or from Mr. Bowles, that would not have been improper because there was a filed motion saying that Bowles and Spiro et al. Could share information. The reason that had to be filed is because most of the information being shared would either be attorney-client privilege or work product. So both of them needed clearance from their clients to share that information with each other. Lawyers can't just call up another lawyer and be like, what's T? Privileged, work product, attorney-client privilege. So that's why it is part of their own ethics. Look, defense attorneys get to take the tea to the grave. They don't have to say shit in most circumstances. Asterisk, there are limited circumstances where defense attorneys do have to say shit. But just like Brady is a huge obligation for the prosecution, attorney-client privilege is a huge obligation for the defense. It is like the core of what they do. Work product is the core of what they do. And for defense attorneys, they understand well what is and is not privileged, what is and is not work product. And we saw it in the YSL case when Steele was saying to the judge, standing his ground in court saying, arrest me then. I'm not turning this information over. Like, it's not because it's some ride or die shit, but Steele seems like a ride or die type of attorney. That's privileged. I don't have to tell you anything. So put me in jail. The court's eventually going to overturn it and you're going to look like an idiot, but put me in jail then. Because I don't have to tell you. I don't have to tell you how I learned it. I don't have to tell you who told me. I don't have to tell you where I got it. And the only reason I'm telling you that I know it is because my client said I can tell you that I know it. So their world of privilege is different than a prosecutor's. Kari's a special prosecutor. She generally works as a defense attorney. She knows this inextricably. Victoria said, most ride or die shit is, can you please put me in a cell with my client? Yep. Put me in a cell with my client so we can keep working. Steele was ready to go. Steele's what you want in a defense attorney, right? Spyro is what a lot of people want in a defense attorney. Steele has got a little bit more swagger. Sorry, Spyro. He just does. He's got more swagger. But is that Riz? Is it now Riz? Damn it. I can't keep up. But Steele was just like, let's go. Steele's also been representing Young Thug and others for a substantial amount of time. Like, Steele knows his job well. He's the attorney you want. Hold on. My heater is facing the wrong way and it's fighting with me. Now I'm so fucking cold. My toe that's angry is freezing. Hold on. All right. Better. Move it. I like to move it. And I can't stand up because my fucking toe hurts. All right. Let's keep going. These are things the attorneys know. These are things they know well. This is like a core fundamental of their job. And I know this is one of the things that frustrates people with this case is it's kind of a no harm, no foul thought of, but if they know, is it a problem? Yes. And that's where I see people get tripped up on this, stuck in the, is it fair? The law is not always fair, by the way. But when it comes to constitutional rights, it might not seem like the fair result is the just result. And I think there's a lot of bumping up against this based on what we saw in the Hannah trial, based on what we saw so far in the Baldwin trial, based on Baldwin's own interviews and words. I can understand where there's a disconnect between the just result and the fair result, feeling like those should always be the same thing. And sometimes they're just not. Like, legality, morality are not always in lockstep with each other. So in this, does it feel fair that even if the defense knew, the case still gets dismissed because the prosecution didn't turn it over? I get that that doesn't always feel correct. However, the prosecution has an obligation, and if they do not meet that obligation, the consequences strike at really preventing the prosecutor from doing it again. And this is a big remedy because this is a big problem, because you don't want prosecutors running wild, which you don't want. And when you see it, it's awful. When you see prosecutors doing shit you don't think they should be doing, you look at it and go, what the fuck? It hits at your core sense of fundamental fairness and justice when you see prosecutors doing shit that you're like, why the fuck are you doing that? So when you look at a case like Karen Reed and you're like, why the fuck are the prosecutors doing it? Same energy for the prosecutors in the Rust case, even if you don't feel the same way about the two defendants. And that can be hard, right? And I get that it can be hard. This is where we all get to put our feelings aside and go law brain. It's why lawyers can seem like total dicks sometimes, because lawyers are really good. And anyone who is hyper analytical in this way gets it when people are like, that's harsh. And you're like, oh, I forgot to talk about the feelings side of it. I was just in the analytical side of it. Lawyers are often in the analytical side of it and not in the feelings side of it. And it can come across very cold when you just talk about the analytical side of it without acknowledging the feelings side of it. I don't always do it well. I try to, but I don't always do it well. Because when I get stuck down in the lawyer brain, we're just doing the analytical. Not acknowledging the feelings behind it can feel difficult. And for everyone who is neurospicy in a way where you can get trapped into the analytical without reading all the feelings, you know what I mean? Because people are just like, and you're like, wait. Damn it. It can be hard to explain. Also, it's why I love all the neurospicy lawyers, because they have found a space for themselves. For anyone who is neurospicy and is like, you know what? I don't know if law is ever right for me. If you find yourself struggling to understand why other people are emotioning the way they're emotioning, appellate law might be the perfect place for you. No lies. Appellate law might be the perfect place for you. All logic, no feelings. Just all logic. Just cold, hard law. These facts, this law, this case law, this said that. Like the result, don't like the result, don't give a fuck. What is the lawful law? Don't like this law, too bad, not my problem. Legislature, go write a new law, vote. That's it. Don't care about your feelings. So appellate law might be the place for you. So for everyone who is like, this is hard. Yeah, law might be right. For those of you like Mallory, Mallory's like, I'm all feelings. I get that. There were people that dropped out of law school in 1L that were like, I cannot separate the two. This is miserable to me. And then there's people who go into law school like Myers that are like, oh, that's heaven. Yes. I'm sure engineers feel the same way, where it's just like, feelings. I mean, it's a bridge. Like, will it stand? I don't care if anyone's feelings are hurt by the design. So that's where we get the hyper analytical, when lawyers, especially when lawyers discuss law together, it can feel disconnected. We're very good at parsing the two. I'm broken at this point. I'm not great at parsing the two anymore. It was hard for me to parse the two always. I think that, I get to a Legally Blonde speech at the end. I think that the way I could acknowledge feelings made trial work very good for me, because I worked well with people, witnesses, victims' families. However, it was difficult personally for me and took a toll on me to try to separate the feelings out of sometimes presentation, because there are things that'll choke you up that will just choke you up. So my barricade isn't as good as it used to be, but it didn't work well for me having that barricade in place. I'm an empathetic person by nature. So to try to wall off being empathetic when somebody's testifying about the worst shit that's ever happened to them so you can sit there and not cry in court is hard. And it takes practice. And it takes practice to be able to switch between the two. My husband used to just call it work mode. He's like, oh, you're in work mode right now. I'm like, oh, work mode's not helpful at the moment. And it's hard to switch. So there's been a lot of soliloquies today. Apologies. Let's get back. I'm disassociating from the fact that Kari Morrissey's having the same argument we've had a million times. Like, we've heard all of this. I'm shocked that we're hearing it again. So. Cheryl Ray said, 35 years in HR, I'm burnt out on feelings. I get that. Take care of yourself. Burnout is real. Burnout is real. So. All right. Sometimes those walls of self-preservation are both a blessing and a curse. All right. Which is why, again, lawyers can seem cold. But then when we're all together, it's just dark and hilarious, and whiskey is involved. Emily, are these healthy coping mechanisms? Look, man. AV asks, what the fuck are you drinking out of? It's a coffee pot. It's a jug of coffee. That's what we needed today. I hate that we're still talking about this, but now I'm too invested to skip it. During an on-the-record sidebar, the prosecutor asked the court to ask the defense team about shit they can't disclose. The court said no, the way the court should. Despite evidence that the defense team was aware that the ammunition in question was similar, I think that's taking leaps and bounds with what the record has shown to us. Maybe there's more on the record. Don't know. The judge's ruling relied on the fact that they were unaware of the evidence until the third day of trial. No, that's not how I read the ruling. The ruling relied on the fact that the prosecution did not disclose it. The case against Mr. Baldwin was dismissed with prejudice for the following reasons. We don't need any of this information. An interested party, Troy Teskey, the good friend of Hannah Gutierrez's father, provided 3 rounds of ammunition with the same characteristics as live rounds found on the set of arrest to the Santa Fe County Sheriff's Department more than 2 years after the death of Miss Hutchins. Teskey previously disavowed possessing the ammunition and previously provided 2 photos of ammunition in his possession that did not depict the ammunition he provided to Santa Fe County Sheriff's Department on March 6th. Ammunition identical to the rounds of ammunition provided by Troy Teskey to the Santa Fe Sheriff's Department can be purchased at retail stores throughout the country. A, that's not in evidence based on anything other than Kari saying so. B, Troy Teskey should have come in as a witness then, and all of this could have been done in court. And C, it doesn't matter. And D, you've left some shit out. The ammunition was never disclosed to the defense, but there are clear indications that well before trial, the defense knew of the existence of the ammunition, knew it had been turned over to the Sheriff's Department, and knew that 3 rounds had the same characteristics. I don't think there's evidence of that last part. Sin N said, Emily, you sound so downtrodden. I'm so annoyed that we're still retreading the same ground. It's gotten to be ridiculous. And I'm kind of mad that the court didn't make Kari pay the defense cost. I'm rarely like sanctions, but yeah, I'm kind of disappointed the court didn't charge costs for Kari doing this to Kari to pay the defense. Well, the defense is going to try to take the money out a different way. They're going to find other methods to extract that payment. We're getting to that next. Emily, it's 2 hours into the show, 2 hours and 22 minutes and 22 seconds that's a great time to look up, into the show. And we haven't gotten to the 75-page ruling. This is why you're supposed to stick to one topic a day. The law nerds don't care. It's fine. The defense implied to the court during arguments on July 12th that they were unaware of the ammunition. Yeah, they said that the prosecution didn't turn it over. During the pendency of the case, the court granted Baldwin's defense team leave to file motions in excess of the permitted... Oh, not again with the pages. Again. During the pendency of the case, the court granted Baldwin's defense team leave to file motions in excess of the permitted page limits on 3 separate occasions. 3 separate occasions! The first and only time the state requested leave to file a motion in excess of the permitted page limits concerned the state's motion to reconsider dismissal with prejudice filed on August 30th, and the court denied the state's request.
Your Honor, they always filed over the page limit, Your Honor. And just the one time I asked to file over the page limit, you said no. I can't even believe it. You let them do it multiple times.
I will note that some of the times that the court allowed the defense to file motions over the limit were motions that were consolidated. So the defense was like, if you'll just give me a few more pages, we can do 2 motions in one instead of just filing 2 separate motions. And the court was like, bet. Exactly. Monica S. in the chat said, Your Honor, how could you? First, how dare you? Exactly. And the court slapped Kari, not literally, figuratively, with the way that Kari ranted that the court allowed the defense more pages. Kari brought up to the court, and the court was like, no. The office, this is the only thing we wanted to know. This is the only thing we wanted to know. On all of these pages, this is what we wanted to know. The Office of the Attorney General notified undersigned counsel that the Attorney General would dismiss its appellate efforts if the reviewing court did not recommend summary reversal. Under New Mexico law, only the Attorney General is vested with the power to prosecute and defend criminal appeals in the higher courts. That's the only part we needed. The Attorney General notified undersigned counsel that the Attorney General would dismiss its appellate efforts if the reviewing court did not recommend summary reversal. And they're not going to do that. I imagine there's more information there. I imagine that the Attorney General said, "What the fuck are you doing?" There's more information to that sentence. So the Attorney General was not going to pursue. I'm reading into this. What I'm reading into this is the Attorney General said, no, we're not pursuing this, and that forced Kari to withdraw. Kari cannot appeal this on her own. Only the Attorney General can appeal it. The prosecutor can file notice of appeal and say, Attorney General, please appeal it. There's no Attorney General that's going to take this appeal at all. And that's why Kari filed this on December, whatever it was, and then dismissed it. Like it was what, a month in between? November 22nd. Yeah, it was like a month. The AG's office was like, we're not going forward with this. So in summary, Kari Morrissey filed a multi-page notice of withdrawal of appeal when there were less than 2 paragraphs that were needed. The rest of the filing was to relitigate everything she didn't like that she put in her appeal and everything else she's filed. But now that there is no appeal pending, the case is finally final, which opens the door for Baldwin to sue literally everybody. And that's exactly what he did. So let's get to Baldwin suing all of the all, shall we? And since all of the publications say, in documents obtained by insert name of publication, these documents were obtained directly by Team Baker from New Mexico. So, in documents obtained by us. Filed January 9th, 2025 at 11:37 a.m. in the 1st Judicial District Court, Santa Fe County, Baldwin sues Kari Morrissey, Mary Carmick Altwies, the elected DA, Andrea Andrea, the first special prosecutor, Jennifer Macias, the 1st Judicial District Attorney's Office, the entire office, suing the whole office, Alexandria Hancock, Marissa Popple, Brian Brandel, and the Santa Fe County Board of County Commissioners. Everybody getting sued. Not everybody's being sued for every cause of action. We're going to go through who all these people are. Violation of rights under 1983, conspiracy to cause violation of rights under 1983, malicious abuse of process, which is your malicious prosecution, intentional spoliation of evidence, defamation, violation of the New Mexico Civil Rights Act. Marvin's mom, you are not alone in this sentiment. Marvin's mom in the chat said, EDB, shouldn't Baldwin be happy he's a free man and put this to rest? Why keep drawing attention to himself? The attention to himself aside, I think Baldwin feels that this was a malicious prosecution and that he was defamed, and he has the money to say, I mean, his name's already been dragged through the mud with all of this. So he's pissed. So why not let it go? Because he's pissed. And I think Baldwin feels that he was maliciously prosecuted. We'll see. Notably absent, Erlinda Johnson. I think shooting at Erlinda would have failed. So I'm glad that Erlinda's not in here, but we'll see. So, and I think Baldwin indicated he was going to do this. And why keep drawing attention to himself? He's going to have to be promoting a TV show, isn't he? Because he's got a reality show that's being filmed. So I don't think drawing attention to himself is something he's worried about. But I'm interested to see what shakes out in the process of this case. I'm interested to see what else the prosecutors are up to. If this shines a light on what else the prosecutors were up to, I'm interested to see. I also wonder, and this is speculation on my part, I also wonder if discovery here might unearth things that will be used or beneficial in all the civil litigation. I don't know. But if they try to use the prosecution against him in the civil litigation, it's kind of gone. That ship has kind of sailed now because it was dismissed, but we'll see. Goose. Wait, no, this doesn't say goosebumps. This says, Goober Patromus memo to me, name calling is prohibited in chat. Yes, it is difficult not to name call. It is difficult not to name call, but it is okay to dislike it. Baldwin, through his attorneys at Quinn Emanuel, name continues, brings this action for deprivation of rights afforded by the Constitution and laws of the United States, malicious abuse of process, intentional spoliation of evidence, and the rest of it against all the people. Introduction. And we already read that, so we're going to not read it again. Introduction. The highest duty of all who investigate, charge, and prosecute criminal cases in the state of New Mexico is to fairly and impartially apply the state's awesome powers. You know, not Austin powers, awesome powers. Criminal prosecutions are to be guided by the search for truth and justice, not to pursue personal or political gain or harass the innocent. Look, they're going to continue to call Baldwin innocent. That's not what's been proven in this case. However, he was also not convicted of anything. So, for the better part of the last 3 years, however, defendants repudiated these obligations, blinded by their desire to convict Alec Baldwin for all the wrong reasons. I mean, or because he pulled a trigger on the weapon. Or that. Or both. We'll see. For the better part of the last 3 years, they repudiated their duties, blinded by their desire to convict Alec Baldwin, not blinded by the light, blinded by their desire to convict Alec Baldwin for all the wrong reasons and at any cost. For the October 2021 accidental shooting death, which is missing and I've inserted, of Helena Hutchins, the shooting death of Helena Hutchins. Defendants' misconduct in their pursuit of Baldwin and the trial judge's condemnation of them has already drawn worldwide attention. The worldwide attention aside, the misconduct and the condemnation from the judge are the core here. But this action is necessary to vindicate Baldwin's rights and deter defendants from attempting to do this to anyone else. Look, Kari Morrissey is a special prosecutor for this case only. She's not going to do this to anyone else. She's not going to be a special prosecutor for anybody else. From the moment defendants and their agents set foot on the scene of the incident, it should have been apparent that Baldwin had no culpability. No, I disagree on that. Yeah, I disagree. I think that is a heavy-handed sentence. Minutes before, a member of the crew had handed him a prop gun and loudly called out "cold gun" to assure Baldwin and everyone else present that it had been inspected and contained only non-explosive dummy rounds. They go on to say, unbeknownst to Baldwin, the prop had been loaded with live rounds that looked similar to dummy rounds. The prop fired a live rounds and killed Hutchins. I agree with that. I also agree that Baldwin didn't know it had been loaded with live rounds. However, it doesn't mean he's not culpable under the laws in New Mexico. But civil litigation will figure that out. Defendants sought at every turn to scapegoat Baldwin for the acts and omissions of others, regardless of the evidence or the law. Insert a previous rant in your mind about how annoyed I am that they just let the first AD plea like immediately to basically nothing but we need you to testify against Baldwin. That still pisses me off. This included defendant Andrea, the special prosecutor who used the prosecution of Baldwin to advance her simultaneous run for the New Mexico legislature. Yeah, gross. Don't do that. It included defendants unlawfully charging Baldwin with an enhancement to increase the potential sentence from 18 months to 5 years. I mean, the first time I reviewed this case, I called that out and said, I don't even think they can do that. They couldn't, and they dismissed it, which makes them look terrible. Even though the enhancement was not enacted until after this incident, man, it wasn't retroactive. It included special prosecutor Kari Morrissey, who wanted to teach Baldwin, quote, a lesson because she deemed him to be an arrogant prick. Look, may or may not be the case, but also she said that's not what she said. And in trial, they asked her if she called him a cocksucker. So did she call them both? I don't know. We'll see. And it included her extracting an indictment by manipulating the evidence she presented and choosing not to present. I don't know if that's true or not. Look, indictments are not always hard to come by. And I think under the laws, there is room to say pointing the weapon at someone and pulling the trigger is enough under the way the law is written in New Mexico. So, did Baldwin pull the trigger? Yes. Did he cock the weapon? Yes. That is what all the evidence has shown. Is that culpability under the law in New Mexico as it's written? I think it can be. Let's see. Most notably, it included certain defendants' intentional concealment of exculpatory evidence and then lying from the witness stand during trial about their cover-up. If that's true, problem. For the first judicial district, Judge Summer was, wait a second. That was not the last straw. Oh, no. The witness stand was a huge issue. Oh, this isn't OCR. God, I hate these documents. For first judicial district Judge Mary Marlowe Summer, that was the last straw. During those 2 days, Judge Summer heard testimony from SFSO, Crime Lab Technician Marissa Popple, and Lieutenants Brian Brandel and Alexandria Hancock about the circumstances under which live rounds had come into defendants' possession and how defendants intentionally chose not to log them to the case file at the insistence of Special Prosecutor Morrissey. Morrissey said that's not how it went down. Hancock said it was. We'll see. To keep Baldwin from knowing about them, no one said that directly, but that's the direction that the lawyers are proposing this under, because why else do you do that? Popple and Hancock said it was so things wouldn't get confusing. That's not how Baldwin feels about it. Summer inspected the ammunition. Yes, she did. Down in the well with glovey gloves on her hands. Summer inspected the ammunition that defendants had failed to disclose and instantly recognized their exculpatory significance. That same day, Morrissey called herself to the stand and gave perjurious testimony in an attempt to justify her misconduct. She keeps trying to justify it, doesn't she? Judge Summer found that, quote, the state's willful withholding of this information was intentional and deliberate. If this conduct does not rise to the level of bad faith, it certainly comes so near to bad faith as to show signs of scorching prejudice. Based on these findings, the judge concluded there is no way for the court to right this wrong, and dismissal of the criminal case with prejudice was the only warranted remedy. Defendants must now be held accountable for their malicious and unlawful pursuit of Baldwin. These two things might be different. We'll see. Defendants must now be held accountable for their malicious and unlawful pursuit of Baldwin, although no verdict in this civil case can undo the trauma the state's threat of conviction and incarceration has inflicted. Baldwin has filed this action to hold defendants responsible for their appalling violations of the laws that govern their work, or governed their work. Is that an implication that Kari Morrissey is no longer acting as a special prosecutor? We'll see. Jurisdiction and venue. This all happened in New Mexico. Parties. Baldwin. Civil complaints. Baldwin is an actor, philanthropist, and political activist. He is a resident of New York. Morrissey is an individual. Suit brought against Morrissey in both her individual and official capacity, which is interesting because there are going to be issues here of privilege. We're going to get to that later, but legal privilege. And there are going to be issues here that will have to be litigated. I think this civil litigation will be quite interesting to see the difficulty of going through and suing a prosecutor's office, suing agents of the government, suing an entire board of supervisors or county commission. There are some protections for how they're doing their job, and walking through those arguments, I think, will be illuminating. Morrissey's being sued as an individual and as the special prosecutor. The office of the district attorney appointed her special prosecutor in connection with the Rust prosecution. She's a resident of the state of California. She is? Really? Didn't she have a law firm in That's a rabbit hole for later. The elected DA is the DA and a resident in New Mexico, and she is being sued both individually and in her official capacity. We'll see how they get there. Ned Ludd said, can you sue a public official? It's difficult. It's difficult. Rolling Along said, let's not forget, no matter what evidence would have been put on at trial, it was still up to the jury. Yes, we don't know if he would have been convicted. Very true. Defendant is the former district attorney for the 9th Judicial District. So Andrea was also an elected DA, but in a different district, and is now a member of the House of Representatives and resident of New Mexico. She's being sued individually and officially. She was appointed special prosecutor in connection with Rust, and then she withdrew. Defendant, this is who I didn't know. Defendant Paige Macias is an assistant DA for the 1st Judicial District and resident of New Mexico. She's being sued individually and officially. We'll see what happens there. Because as the ADA, she's kind of second in command to the elected DA generally. Hancock is the IO from this, and she's being sued individually and officially. Popple is the crime scene tech being sued officially and individually. Brandel is a supervisor sued officially and individually. Defendant 1st Judicial District Attorney's Office is a state entity. How they get through suing the entire DA's office is going to be interesting. It's going to be interesting. I'm interested to see if they had to file, because in some jurisdictions you have to go through an administrative process before you can sue agencies like this. So I'm real curious to learn what this process is like in New Mexico. Defendant Santa Fe County Board of County Commissioners is a political subdivision of the state of New Mexico. They're the ones that approved the funding. They say at all material times the county was a government entity and a local public body as terms are defined in 4143. These are going to be interesting too, how they get through the New Mexico Tort Claims Act, and is liable for its conduct and for torts committed by its officers for which immunity is waived. I don't know if immunity is going to be waived here. There's going to be a lot of litigation about immunity here. Facts common to all claims for relief. We're going to get through a complete retelling of what happened. We'll see. But we're going to get through a complete telling of what happened. I will probably zoom through some of it. A big question here is how they're going to get to suing people in their individual capacity, not their official capacity. And if you're going to be able to sue all of these government entities in this way. So the Rust production. In 2018, Baldwin began working with writer-director Joel Souza on a Western movie titled Rust. Rust tells the story of a boy in 1880s Kansas who accidentally kills a local rancher and is sentenced to hang. After being broken out of prison by his estranged grandfather, an outlaw named Harlan Rust, they flee to New Mexico on a dangerous journey through an unforgiving landscape, forming a close bond along the way. Jensen Ackles was in it. That's what I got. Throughout 2019 and 2021, Baldwin worked on the project with Souza, and then everybody else on the team. They began production. Baldwin was also a producer, but his authority was limited to creative decisions. Baldwin lacked the authority to hire crew members and make other non-creative decisions. That's all being litigated in the civil case. Gabrielle Pickle was hired as the line producer, And then they hired others and the units and what have you. Production filming began October 6, 2021. That day, Baldwin and his production company, Eldorado Pictures, entered into a producer agreement with Ryan Smith and Russ Movie Productions, LLC. The producer agreement reflects Baldwin's creative role and his lack of authority on hiring and budget decisions. He didn't arrive on set until the second week of filming. So he's saying, I didn't hire Gutierrez, has nothing to do with me. Budget has nothing to do with me. How much budget, how little budget, none of that has to do with me. Soon after arriving, Baldwin met with Hutchins, the cinematographer, also known as the DP, and Souza. They discussed their creative vision for the film, how to tell the story through the camera, taking advantage of the vast, quiet expanse of New Mexico's landscape. The one thing that did strike me in this trial is looking at how beautiful the scenery was in the shots that we saw. I can see why they picked it to film there. Heather in the chat said New Mexico repealed qualified immunity. That would explain how they go forward. It'll be interesting to see how they argue it, and I'll have to go look at when that happened because I'm curious. So that'll be interesting. But when they showed shots of the movie, I can understand why they picked to film it there. How they continued going forward and releasing it sits weird with me. Not my decision to make. But some of those shots that we saw in trial were just gorgeous. So I get it. I get it. They did not discuss safety at the meeting and did not, and at no point did Baldwin discuss gun safety with anyone beyond Zachary Gutierrez, Reed Halls, and Nicole Montoya, the props assistant. Control over firearms on sets. We're not relitigating this. The armorer is in charge of the firearm safety on set, along with the first AD. The actor has to follow the rules of safety. That's where we're at. We're not going with a description of what is a dummy, what is a full load, half load, or quarter load blank, and what is a live round. We know who the prop master was, Sarah Zachary. We know who the armorer was, Gutierrez Reed. We have sat through a trial and a half on this. This still doesn't stick with me well. In addition to the prop master and armorer, the first AD is in charge of set safety and is the, quote, last line of defense for firearm safety on set. I still want to know how those decisions got made, that nothing happened to Dave Halls. Maybe it's because he took responsibility early. Maybe it's because they wanted him to testify against Baldwin and Hannah. Although industry guidance instructs that it's best to avoid pointing a firearm at anyone, the same guidance notes that this does occur while making a movie and explains that when pointing a gun at another is absolutely necessary, it should be done in consultation with the prop master and his or her designee and the first AD. I will note that from all the evidence we've seen in the trials, that didn't happen. The scene, this is what's so frustrating about this, because this never should have happened. I mean, you look at all the criminal cases and you're like, this never should have happened. This never should have happened. It did. But the amount of failures that happened that ended up with Helena Hutchins being killed is staggering. The blocking out didn't call for Baldwin to have a weapon in his hand. The blocking out didn't call for him to be grabbing or moving that weapon around when they were blocking after lunch when this happened. The weapon shouldn't have been loaded. He didn't need it. He didn't need to manipulate it. From everything I can tell from the testimony we've seen, from the interviews we've seen, from everybody talking about what was happening that afternoon, if anything, he was moving the gun around his waistband, and that was it. After lunch, moving the gun around his waistband and blocking that out. And for the blocking, maybe didn't need that at all, but definitely didn't need to pull it out and point it at anybody. Didn't need his finger on the trigger, didn't need a cock, didn't need any of it. And it didn't call for the weapon to be pointed directly at another person, especially not the cinematographer. Also, this was not the day to do these shots if the video village was down and you couldn't remotely operate the camera. If you needed to point it down the barrel of the camera, then no one should have been behind the camera. Like, there's so many issues with all of this, but this didn't happen. There was no consultation, none of it. At the bottom, and again, pointing it down the barrel of the camera is different than pointing it off camera at the cinematographer. I just can't. First AD yelled cold gun. Issues abound. Baldwin received standard firearms training on Rust. The day he arrived on set, he received firearms training from Rust armor Gutierrez Reed. The training lasted 90 minutes. There's a lot of discrepancy about what that looked like and whether or not he was having Hannah Gutierrez train him or he was having Hannah Gutierrez film him while he made short videos messing around with the guns for his kids. But the only reason I take so much issue with this filing is because we've watched 2 trials on this and seen a fuck ton of filings. They are filing their civil lawsuit in the light most favorable to the plaintiff. In this case, the plaintiff is Baldwin. We just have so much information about this that it's hard not to be like, but what about this? But what about that? In most cases, when we get to a civil complaint, we don't have nearly this amount of information that we do. We have so much information. We have gone through, 6 civil complaints, 2.5 trials, pre-trial litigation, post-trial litigation. We've gone through so much with this case. During the session, Gutierrez Reed reminded Baldwin of gun safety measures he had learned at substantially similar gun training throughout his career, such as pointing the gun down when cut is called. Cut, motherfucker. Such as pointing the gun down when cut is called, to not force the gun if it jams, and to not fire it when empty. Gutierrez also reminded Baldwin that that he would need to feign the prop recoil because blank rounds do not generate any. But Gutierrez Reed did not instruct Baldwin that he should check the gun himself. In fact, she told Baldwin his. I believe that's true. Again, I believe the prosecution here, among other things, should have always focused on the cocking the gun and pulling the trigger and having his finger inside the trigger guard, and never should have focused on whether or not it was his responsibility to check the gun. I think that is in dispute. Baldwin followed Gutierrez Reed's instruction during the gun safety training and throughout his time on Rust. No, he didn't. We saw video. Smurf Anna agreed. Smurf Anna said, I disagree with 45 based on video. Yep. Cut was called and he was still firing off blanks, which led Joel Souza to saying, cut, motherfucker, under his breath. We have seen that he was not following all of the rules. That doesn't change or make okay what the prosecutors did here. I just take issue. Emily, if you keep going through this with a fine-tooth comb and argue with every sentence they say, we're never going to get through the end of it. True. I should be more interested, and I'll try to be, in how they are seeking redress here and why. On October 21st, 2021, the Rust cast and crew were filming a scene in a small church where Baldwin's character, Rust, takes cover after a shootout. The scene involves a close-up view of the revolver he is holding that he is required to cock, i.e. pull the hammer back, before a shootout begins with shotguns booming and Colts exploding. Yes, before Jensen Ackles walks into the church. We watched all this happen in trial. They began rehearsing the scene before lunch with Baldwin practicing his cross draw for the camera. In a video recording of the rehearsal, Souza told Baldwin to draw and point the gun and whip it out in front of the camera. Souza didn't say that. Baldwin said that. After Baldwin practiced the move a few times, someone off camera said, nice. To thine own self be true. Back to Clueless. No, actually, I remember Mel Gibson and he didn't say that. It was that Copernicus guy. Baldwin didn't say that, or Souza didn't say that. When the cast and crew broke for lunch, Gutierrez Reed took the pistol from Baldwin, Sousa, Hutchins, and Baldwin stayed behind to discuss the insert shot they were planning to film after lunch, which involved capturing a close-up of Baldwin's cross-draw with the camera tightly focused on the gun. They understood that to achieve this close-up, the unloaded pistol would need to be loaded with dummies so the pistol would not appear on screen to be unloaded. At some point during or after lunch, Gutierrez-Reed loaded the pistol with what she believed were 6 dummy rounds. Gutierrez-Reed then brought the pistol into the church and showed it to Halls. Telling him she had loaded it with dummies, she rotated the cylinder for Halls, who agreed that the prop gun was safe to handle. Halls handed the gun to Baldwin. This conflates the timeline because Gutierrez-Reed wasn't in the church when Baldwin got the gun based on what we saw at trial. Halls announced there was a cold gun on set. That meant that the prop gun had been inspected and was incapable of firing even a blank or causing harm. Meanwhile, Hutchins continued to evaluate her camera angle for the scene. In Baldwin's experience, the DP has significant input into the actor's performance, particularly what to do or not to do. Hutchins directed Baldwin accordingly. Oh boy. We're going down this road of Hutchins told him to point the gun at her. Okay. Baldwin was sitting in a church pew looking at Hutchins. He held the gun, which Halls had just announced was safe. Hutchins was standing camera right to Baldwin's left next to the camera operator. And looking back in the camera operator also sued and has a slightly different breakdown of this. Looking back and forth between Baldwin and the camera operator's monitor, she was determining how best to angle the camera and what movements Baldwin should make for her to capture the cocking of the gun that the script called for. The script called for the gun to be at the waistband and come slowly out of the waistband. That's what it says. Based on the script supervisor testifying at trial. Baldwin asked Hutchins what she would like him to do. He pulled the gun out slowly and held it still before Hutchins began giving further direction. He went through this in his interview too. This is his version of events. I have not seen anyone else that was in the church say that this is what was going down. I've only seen Baldwin say this. They go on to say she described how she wanted Baldwin to place the gun. She told Baldwin to hold the gun higher to point where it was directed towards her. As she gave these instructions, she was looking carefully at the monitor and then at Baldwin and then back again. Baldwin asked Hutchins if she wanted to see him cock the gun as the script required. Again, that was at his waist. He says that Helena responded yes. He tipped the gun down so that the camera would focus on his hand action at the top of the gun. While performing this action, Baldwin asked Hutchins, am I holding it too far down? Do you see that? Hutchins said she could see Baldwin's action. Again, he's the only one that's described this. He has described this repeatedly. As later became known, a live round discharge. It became pretty apparent. A live round discharge from the gun struck. They've had to work around the fact that he pulled back the hammer and the trigger here. As later became known, a live round discharged from the gun and struck Hutchins, traveling through her body and striking Sousa in the shoulder. Both Hutchins and Sousa fell to the ground. Panic and confusion immediately ensued. No one understood what happened. Baldwin and others in the church were ordered to leave. The on-set medic and others rushed to render aid to Hutchins and Sousa. Russ script supervisor Amy Mitchell, who also has a civil lawsuit ongoing, called 911 and told the operator 2 people had been accidentally shot on a movie set by a prop gun. Again, saying it was an accident doesn't change that there can be culpability. That's the whole point of the section he was charged under. The section he was charged under is for something that was an accident. And then there are other components to it. We're not breaking it down again. A few seconds later, Mitchell can be heard saying on a recording, this fucking AD, he's supposed to check the guns. He's responsible for what happens on set. Again, don't disagree. But it doesn't mean there aren't others. Multiple people can be culpable. Paramedics arrived shortly and worked to stabilize Hutchin and Souza. We've watched the video of all of this multiple times. The cast and crew were gathered, still reeling from the incident. Mitchell approached Baldwin and said, "You realize you're not responsible for any of what happened in there, don't you?" Okay. Maybe Mitchell was trying to be compassionate. That doesn't change legal culpability, but okay. Hutchins was airlifted to the hospital but succumbed to her injuries. Yeah, Souza was treated at the hospital and recovered. The initial investigation was tainted by the prosecutor's malice towards Baldwin. I mean, I'm interested to see what they say. Officers arrived to set less than 15 minutes after the 911 call. Chat, was it that fast? I don't remember. When they arrived, they did not separate the witnesses, instead allowing people to mingle and talk about the incident and speculate about what might have happened. Nor did law enforcement personnel immediately establish a perimeter around the area, instead allowing cast and crew to move freely around. Again, we watched all the body cam video. I'm interested to see what the prosecutors have to do with it. Law enforcement did not secure the prop truck where the property department and armor stored their materials for 6 days, leaving critical evidence vulnerable to manipulation. Deputy LaFleur asked Baldwin, who immediately said, "I was the one holding the gun," and asked, "What do you need?" Okay. After changing out of his clothes and giving them to law enforcement, Baldwin voluntarily drove himself to the station and sat for an interview with Detectives Hancock and Telemonte. He spoke freely to Hancock. I mean, you can go watch his interview for over an hour. He did do that. B2 said, "I thought it was 40 minutes, but I could be wrong." Yeah, I don't think it was 15 minutes, but it would be odd for, them to have that wrong after sitting in trial. But anyway, he spoke freely with Hancock and Telemonte for an hour, declining their invitation to have a lawyer present. Don't do that. But, I mean, they're trying to make it seem like he had nothing to hide. Again, you never know all of the laws. I'm sure Baldwin had no idea what the laws were on negligent homicide in New Mexico. At the time, Baldwin had yet to learn what they already knew, that Hutchins had died. They waited until the interview was over to tell him. Yeah. I'm not yet seeing anything about the prosecutors. The investigators looked into how a live round got into the gun. From the start, investigators focused on the key question: how did live ammo end up on a movie set? Where the presence of live ammunition is, in the state's own words, incomprehensible. Yep. Questions about Baldwin's handling of the firearm, whether he cocked it or pulled the trigger, and where he was pointing it when it went off, were treated as an afterthought. I don't know about that. For example, although Baldwin consistently maintained that the gun just went off and that it would have defied his normal practice to pull the trigger during rehearsal, investigators did not swab the trigger for DNA. Okay. I wasn't persuaded by this at trial. I'm not persuaded now. Baldwin was holding the gun with his finger on the trigger. Like, what? Within a matter of days, however, things began to change as elected officials and high-ranking members of law enforcement became increasingly involved in the case. Amid this transition, the investigation's lead detective stepped down and a new detective took over. I have questions about that, but okay. According to Detective Hancock, because I thought it was I forget what happened at trial. According to Hancock, prosecutors from the first district were heavily involved in the investigation from the beginning, with investigative decisions being made collectively by a team that included prosecutors. Up until this point, the investigation into the source of the live round was focused on whether the lethal round came from the crew of Rust, like Gutierrez or Zachary, or outside the crew, like Seth Kinney. I think that's an appropriate question. As prosecutors became more involved in the case, their focus shifted from identifying the source of live ammo and instead fixated on Baldwin. I think both things happened together. The shift occurred even as more evidence emerged that Seth Kinney, a third-party ammo supplier, may have been the source of the live round. And it continued despite the consistent finding throughout the investigation that it was not the actor's job to check the live rounds. I think we know that pointing the weapon is the bigger problem here, but whatever. Driven by the prosecution's agenda, I read SFSO and I'm just thinking, again, California. Santa Fe Sheriff's Office began to ignore critical evidence as to how live ammo ended up on set. For example, they waited 6 days before executing a search warrant on the prop truck, the vehicle where firearms had been stored. At Gutierrez Reed's trial, Detective Hancock testified this delay occurred because they didn't have information until later on that this prop truck had been involved in the props department and that we would potentially need to be looking for evidence there, which is why we didn't conduct the search until a few days later. I mean, I don't know if that's fuckery or if that's just like, yeah, we didn't realize where all the evidence was. I mean, I don't think that, I don't think, I don't know. I don't know if that's fuckery. I think that's like, okay. They go on to say that testimony was false. Within hours of the incident, Hancock knew of the importance of the prop truck. When Gutierrez Reed told her that, quote, the guns and the dummies and everything are kept on the prop truck. I mean, okay. In fact, the search warrant states Hancock conducted an interview with Hannah Gutierrez, who advised on the day of the incident that firearms were secured in a safe on the prop truck and that ammo was kept inside the prop truck. I don't agree with their conclusion here, but that's me. Detective Hancock, they say, lied about her knowledge of the prop truck to cover up the real reason they waited 6 days to execute the warrant. I disagree with their conclusion here because I can understand from all the testimony we've seen that Hancock believed that the weapons and ammo at issue were already in police custody and that there might not be any weapons or ammo remaining in the prop truck. Was my understanding that the weapons and ammo involved in this were taken off of the set at the time this happened. But they read that less generously. Of course they are going to. They say Hancock lied about her knowledge of the prop truck to cover up the real reason they waited 6 days. Prosecutors were not interested in pursuing the source of the lethal round because if it turned out that the round came from an outside source, such as Kenny, it would be difficult to blame Baldwin. I disagree with that entirely. I think it would be, under the way the law is written in New Mexico, I don't even think you need, for Baldwin's prosecution, I don't think you even need to know where the round came from to prosecute Baldwin. You need his hand on the gun. But I think the prosecutors didn't do a good job of that either. This was confirmed by 2 sets of prosecutors, both whom sought to hold Baldwin criminally responsible for failing to supervise crew members based on his role as a producer. And for failing to adhere to gun safety rules. But they left that part out. They waited more than a month to execute a search warrant on Kenny's business, which sucks. Yeah, they shouldn't have. The delay would be troubling under any circumstances, but it's particularly troubling here given that Detective Hancock knew at the time, or given what Detective Hancock knew at the time. On November 1st, 30 days before conducting the search at PDQ, Hancock met with Kinney at the station. During the meeting, Kinney phoned someone named Joe Swanson to determine the whereabouts of several hundred live rounds that were reportedly given to Kinney that were said to match the live rounds found on the set of Rust. When Swanson told Kinney that the rounds had been, kept, quote, loose in an ammo can, Kinney hung up the phone and swore repeatedly, shit. Because the ammo can Swanson was referring to had been sitting at PDQ all along. Once he was done cursing, Kinney stated, well, Gutierrez Reed didn't do her fucking job. That's also true. Suggesting that even if he had supplied live ammo to the set of Rust, he couldn't be blamed for Hutchins' death. Even though Hancock was present when Kinney realized that he may have been the person who inadvertently supplied live ammo to the set of Rust and watched him curse at this realization, she indefensibly waited 30 days to search Kinney's business. Yeah, I think that interview, if it is as presented here, because we've never seen all of Kinney's interview, if the interview is as presented here, I feel like you have grounds for a search warrant, given everything. This gave Kinney a month to dispose of any evidence linking him to the accident. When they executed the warrant on November 30th, the ammo can was empty. Conveniently, someone had even written empty on the can itself. Isn't that weird? I'm with them on the smoke for Seth Kinney. I'm with them on that. Like, what the fuck? They go on to say that the sheriffs also failed to pursue other leads that may have identified the source of the live rounds, which would have weakened the state's case against Baldwin. I don't agree with that. I don't agree with the framing here. I've repeated myself as to why, but when we got to the trial of Baldwin, and they're talking about at the time of the investigation, but when we got to the Baldwin trial, his role as a producer wasn't even allowed to be brought up. So I don't think identifying the live rounds is necessary. That is my prosecutor brain. That is what I think. I don't know if the prosecutors in this case recognize that. Sometimes you got to keep it simple. I think they could have kept it simple here. Did Baldwin violate gun safety rules when pointing the gun at Helena Hutchins? That is your simple question. Not what his role was as a producer, not whether he should have known Hannah Gutierrez wouldn't chuck the gun well, not whether or not Dave Hall said cold gun. What did Baldwin do when it was in his hand? So I think we have changed the premise a bit here, but it's their civil lawsuit. However, waiting a month to search the prop house is fucking bananas. Because the first question, you tell me, chat. Tell me. When you heard that this happened, that someone died on a movie set filming a Western, was one of your first thoughts, how the fuck did a live round end up on the set of a movie? Because it sure was one of my first thoughts. Sure was. How is that not everyone's first thought? How is that not the inquiry? How the fuck did live rounds get onto the set? That is literally the question. So waiting 30 days, because what are y'all thinking then? Well, who supplied all the ammo? Isn't that the next natural question? And don't you go look at who supplied the ammo? Like fucking immediately? This still doesn't sit well with me. None of this sits well with me. I don't like it. I don't like it at all. Don't like it. None of this sits well with me. There is none of this sits well with me. And again, whether or not there is other sketchy shit going on here, and I have not ruled out sketchy shit. Like, I have so many questions. It doesn't really change what went on with Hannah, because Hannah's job was to check the rounds and know the difference between the two. Baldwin's job was to handle a gun safely. Dave Hall's job was apparently to literally snitch the second anyone asked him anything. Seth Kinney's job was to make sure that he was providing what he was supposed to be providing to set. So the Seth Kinney wing of this is wild to me, and I hate all of it. So I have quite a lot of feelings there. Just from everything we've seen. I hate the way prosecutors dealt this case. Don't like it. And I wonder if when we get later on if they talk about how quickly a deal was given to the first AD, whose job is like safety, I wonder if they get to pointing at how quickly they took a deal with the first AD, who was in charge of safety, to show that they were just going after Baldwin no matter what. Because when we look at culpability, Baldwin's in there, but the first AD is way the fuck in there. So is Kinney. When I first broke this down on the podcast, when this was first happening, and I was looking at like who might be charged, first AD, prop house, Hannah Baldwin. They say one person reported that shortly after the incident, he had overheard individuals who worked on another film who had come into his shop and had been discussing how some of the people working on Rust had been firing live ammo to shoot cans off posts. This person reported this to the sheriffs, but there was no follow-up. I got questions. Because that was leaked in the media too. And the prosecution, no, I can't say it's the prosecution. Somebody came out and said that wasn't true. They go on to say, as a team, sheriffs decided not to fingerprint or DNA test the live rounds found on set to determine who was responsible for bringing them there. I think they explained that in trial pretty well, but the state destroyed the firearm. It wasn't the state. It was the FBI. The FBI. If the sentence they beat off the cock notch with a hammer isn't in this, I'm just going to be disappointed. I mean, they're not here to write lawsuits to entertain me, but at this point, we heard multiple testimony about the beating of the cock notch, so I'm not going to read all of this. We know that the FBI did destructive testing on the firearm at some point, but that the destructive testing of the weapon wasn't done until after Baldwin did a sit-down interview and said the gun just went off. And so the FBI went, well, how the fuck did that happen? How did the gun just go off? They didn't do that until Baldwin's statements. Throughout the investigation, Baldwin repeatedly told investigators that the gun just went off. Several witnesses who were inside the church also told investigators that the gun just went off. Okay, for the witnesses, that's fair. The witnesses were all doing their job, and all of a sudden, a gunshot rang out. Of course, they were like, what the fuck? But for Baldwin, the gun didn't just go off. At first, investigators did not seem to question the veracity of these accounts. In April 2022, 6 months after the incident, the sheriffs asked the FBI to test the prop gun. According to Hancock, the purpose was to disprove what Baldwin said during a televised ABC News interview. I broke that interview down on the podcast as well. It's part of the playlist for this whole case. On April 21st, 2022, Special Agent Cortez, at the instruction of Hancock, performed an, quote, enhanced test to determine whether the firearm would fire without pressing the trigger. As the FBI knew, and as it told the sheriffs, this testing subjects the firearm to substantial external impact and was all but certain to break it. Right. Cortez wrote to Hancock. Cortez wrote that he and Hancock knew that the requested testing would alter the firearm and it would no longer be in the same physical condition. I don't think this is the serve they think it is. They think it is the serve they think it is. It fired just fine more than 12 times in previous testing. Fine. Cleopatra said, did we ever find out who brought the live ammo in? The prosecution presented evidence at trial that they argued showed that it was Hannah Gutierrez during Hannah Gutierrez's trial. So for Hannah's trial, I also don't know if it matters how the ammo got on set, because it was her job to test it and make sure that it didn't end up in a gun. But that's the evidence they presented. They went through it. Kari Morrissey actually, I think, went through that pretty well in her closing argument in Hannah's trial. They go on to say, despite knowing that this would be potentially destructive testing, no one from the prosecutor's office asked that the FBI lab document the internal components of the firearm before performing the destructive testing. They did it after. Forensic examiner Ziegler conducted extremely aggressive testing on the revolver, striking it repeatedly with a mallet without documenting his process nor endeavoring to hold consistent the force with which he struck it. How hard did you hit it with a hammer? I don't know, a hammer amount. They're out here like, the FBI just said it's hammer time. And just, you go on to say, stunningly, Ziegler admitted that he had never conducted this type of testing outside of a training environment. That inexperience led to disastrous results. I think a lot of this is hyperbole. I don't think this is spoliation of evidence, but all right. We'll see where it goes. They said he didn't attempt to adapt the test to the circumstance of the incident. He just began beating the firearm with a mallet until the trigger and other internal components broke. The notch wore down. It was the notch. It was the notch that wore down. This approach to testing the prop made no sense. Well, they explained it at trial. Go see what you think. FBI's Ziegler inexplicably waited until after he conducted the destructive test before doing what he should have done first, take the prop gun apart to examine it for modification or damage. Well, they brought in the manufacturer of the weapon to talk about the weapon at some point. When he finally did so, he found signs of modification to the prop's internal components. Now they're all Kari Morrissey with this, and they're just like, we're going to keep saying that it was modified. However, the gun was firing properly. So the gun was firing properly multiple and repeated times. For example, the hammer had been rounded such that the sear would no longer stay lodged in the full cock notch and other notches. Don't get me started on the full cock notch. We are too close. We are flying too close to the sun. How many times are we going to talk about cock notches without talking about the books I'm reading in this stream? Probably a few more. But at the second trial, we heard quite a lot from the manufacturer of the gun saying, no, the gun was fine when we sold it. And then we heard from the FBI tester saying, if the hammer was rounded so that it didn't catch the cock notch, then it wouldn't have fired properly the 12 times that they fired it. The state's expert admitted those facts, describing the hammer as peened. God damn it. Why is it peened to talk about the cock notch? Why? Why is it peened? Why is that the word? Who decided that peened was the way to describe this? The state's expert admitted these facts, describing the hammer as peened. Don't peen it. Oh my God. It's like third grade in here with the peen. You joined at the right time. This is the right time to join the stream talking about peens and cock notches. This is the right time. It's the right time. The state's expert... Emily, just get through this fucking sentence. The state's expert admitted these facts, describing the hammer as peened or rolled, rounded off, and very, very rough. Wait, no. Sorry. Rough tool marks. Rough tool marks is what they meant. As the state's experts later demonstrated, the hammer would not engage an intact sear in that condition. Yeah, the cock notch just wasn't having it. So if the hammer won't engage, what are you going to do? Which would have allowed the hammer to fall without pulling the trigger. However, before that, it was fine. But thank you, Spyro et al. For putting cock notch in here at least once. Well, it doesn't say cock notch. It says full cock. No, it does say cock notch. I said we wanted to see cock notch. We did see cock notch. There we go. Thank you, Spyro et al. We appreciate you. There's no way we're talking about this case without talking about the cock notches. So there we go. They say the FBI's failure to examine those components before testing or document the prop gun's original condition made it impossible for Baldwin to adequately reconstruct the prop gun. It seemed that the experts did just fine in reconstructing it, but okay. They go on to say the FBI's failure to document the firearm's original condition before conducting the testing and the failure to ask for it is the spoliation. I don't know how far they're going to get on that because from what I remember from trial, there was quite a lot of documenting about the firearm's original condition, not the internal components, but the firing condition. So I don't know. Are we getting to the prosecutors now? Because we were supposed to be talking about the prosecutors. The first prosecution. This is the prior elected DA, now elected representative, who they say joined the prosecution for political gain. Even though Baldwin was not responsible for ensuring the safety of firearms or ammunition and was told by those who were responsible that the prop gun was safe, the district attorney decided to criminally charge Baldwin pretty close to the beginning of the investigation. To charge Baldwin with involuntary manslaughter under the New Mexico statute, the state needed to believe that he acted without due cause or circumscription, or that he handled or used the prop gun in a negligent manner. Which is where I'm at. That's where I've been at this whole time. When you're getting the way that the involuntary manslaughter is written in New Mexico, and no, not all jurisdictions have involuntary manslaughter charges, but when we're looking at the way that the involuntary manslaughter statute is written in New Mexico, handling the gun in a negligent manner is where I have been all along with this. Did he or did he not? Judy G in the chat, this is a great question. I'm going to hold it till we get to questions, but I wanted to let you know I saw it. It's a good question. We will get there at questions if we ever finish this. We're page 19 to 73. I have not moved nearly fast enough. This should have been tomorrow's stream. It's fine. Let's see. I think, again, the way that the law is written, use the gun in a negligent manner resulting in death is where this case lies. The state also needed to believe that Baldwin's negligence and not the negligence of another was the significant cause of Hutchins's death. I think there's room to argue that. And above all, I'll give you... No, Emily, no. And above all, even if the state did believe those things, its beliefs needed to be based on the actual evidence in its possession. They say the evidence the state purportedly possessed supported the opposite conclusion. Okay, just a difference of opinions is not the same. Sarah asked, did he or did he not? Diddy isn't Spyro's client. That's Jay-Z. Yes, it is. Jay-Z is represented by Spyro. They're saying that the state's evidence supported that Baldwin exercised caution and that even if he had not, Hutchins would still be alive if not for the superseding negligence of someone other than Baldwin, which either would have been Halls or Gutierrez, which is why they are focused on where did the live ammo come from. They say by June 2022, the elected DA had privately decided to appoint the special prosecutor. At that time, Andrea, the former district attorney for the 9th District, was actively campaigning for a seat in the New Mexico House of Representatives. That was a terrible idea. Like, why do that? And Reeb emailed the elected DA on June 9th, 2022 to assure the elected DA that she would not disclose to the media that she had been chosen as special prosecutor. At some point, though, I'd like to at least get out there that I'm assisting you as it might help in my campaign. Lol. It's all fun and games until your texts and emails are read in legal filings. 4 days later, 4 days later, the elected DA made a contribution to Reeb's campaign, indicating that the elected DA is a Democrat, that the Reeb is a Republican. However, the elected DA contributing to her campaign when she is appointing her as the special prosecutor and going to the board of supervisors or the commission and asking for money to pay her is not okay. I don't give a shit what political party you're in, but the contributions are a problem. They listed the political party to show that they are not of the same party, making this stranger. However, what is that anyway? This is terrible. I hate all of it. Don't do that. On August 3rd, the DA announced that the first special prosecutor would join the team. She immediately became the point of contact for defense counsel and indicated that she was the primary attorney reviewing the reports and the investigation. She interviewed witnesses, took proffers, engaged experts, and handled other important matters, like giving a plea deal to Dave Halls. What the fuck? I still need somebody to explain that to me. Get ready to get mad if you're not already mad. On August 30th, the elected DA requested $653,000 from the Board of Finance to pay the salary and the hiring of other personnel for the investigation. Lyndon said this more elegantly than I do, which is always the case that Lyndon says things more elegantly than I do. Lyndon said, suspiciously opportune contributions give me the ick. I hate it. On August 30th, the board was asked for $635,000 to pay for the prosecution, including the special prosecutor, and for hiring a public information officer. The DA's office cited the need for a dedicated public information officer to manage inquiries from the media. The state granted the DA's office $317,000. I'm not surprised that the state was like, I'm sorry, you want $600,000? No, bitch. No. I imagine that the DA's office did not have a public information officer. I am curious if there was no one to fill that role. The state tried the case in the media. The elected DA and the special prosecutors, like all prosecutors in New Mexico, are bound by ethical rules. It's like all lawyers. According to the ethical standards promulgated by the National District Attorneys Association. I mean, that's a little bit different. They say that the primary responsibility of a prosecutor is to seek justice, which can only be achieved by the representation and presentation of the truth. Thus, whether full-time or part-time, the position should be approached as a career, not a stepping stone or sideline. Somebody tell Alec Murdaugh. Quick, tell Murdaugh. No matter what other activities the prosecutor is involved in, her public duties come first. Look, this is, none of this is necessary for this lawsuit, but I understand their point. Some of this is just for the public. They go on to say that the guidelines for prosecutors say that prosecutors should refrain from making extrajudicial comments before or during trial that promote no legitimate law enforcement purpose and that serve solely to heighten public condemnation of the accused. This is part of the reason having public information officers works, because they can put out in court today, this happened. And we have looked at some really good and well done press releases by prosecutors where it's today this happened, this is the charges, this is the accusation, this is a limited amount of evidence that let us hear. That is what we are doing. Everything else will be in court. That is often what you see from prosecutors. Just that, just the facts, and that's it. They say prior to and during a criminal trial, the prosecutor should not make any public extrajudicial statement that has a substantial likelihood of material prejudicing a judicial proceeding. These mirror the rules of ethics with pretrial publicity. These mirror the rules of ethics. And we've seen this repeatedly, and we've covered the pretrial statements repeatedly. They say that the prosecution repeatedly violated this rule. Tell me how. On October 26, 2021, 5 days after the accident, the elected DA started giving media interviews regarding the investigation. Instead of limiting such statements to those that serve a legitimate law enforcement purpose and are necessary to inform the public of the prosecutor's actions, they began characterizing the evidence, e.g., that there, quote, were an enormous amount of bullets on this set. In this case, it should have been status updates. The investigation is ongoing. The weapon is with the FBI for testing. We will make further statement when there is a filing. I have been critical of this because this prosecutor's office would tell you they're going to do something, and then would tell you they're going to do something, and then would tell you what they're going to do again, and then would finally file it. There were so many public statements. It's just do the fucking thing. And then be like, we filed a thing. They made so many statements before they did anything. It was annoying. And kind of weird. I don't disagree with this. Status updates. Again, no one in the public was afraid for their own safety. The public didn't need to know much more than stage of the investigation, and that could have been done through the public information officer for the sheriff's department. So statements could have been, we are working with the sheriff's department to do a thorough investigation on how this tragedy onset happened. We will let you know when we have concluded that investigation, period. The public's not in fear. This is an isolated incident. There were an enormous amount of bullets on set. I don't even know if they would have known that by then. Throughout the end of 2021 and the first half of 2022, the district attorney repeatedly gave national televised interviews and issued public statements that improperly commented on important but contested facts in the case. This is going to their suing the suit against these two. For example, 7 days after the incident, the elected DA told NBC News that Baldwin was the one that pulled the trigger without any objective basis to have reached that conclusion. I mean, other than his police interview, I suppose. But I would need to go through his entire interview because he did talk about handling the gun. So I guess the issue they have is with the direct language of the one that pulled the trigger. His hand was on the gun when the gun went off. Maybe would be more precise at that point. But they say without any objective basis to have reached that conclusion. And before any testing had been done to determine how or why the firearm discharged. I think a curious mind would say, could there have been something wrong with the prop gun, or did he pull a trigger? By the time the special prosecutor joined the case in August 2022, she and the elected DA were preparing for a full-scale media blitz. Not a ballroom blitz, a media blitz, in violation of their prosecutorial duties. On January 18th, 2023, the DA's office announced that it would reveal its charging decisions the following day. This kind of shit I hated. Why? Why? We'll tell you tomorrow. The announcement, then just announce it. An announcement for a fucking announcement. It's like a save the date for a press conference. It's weird. The announcement featured high definition headshots of both and promised there would be no news conference or public appearances by the DA's office in connection with the decision. And then the worst screenshot of the press release about a press release for a press release that I've ever seen. In a and this is not to criticize Spyro, because this happens with the way that the state of New Mexico scans documents into their system and then downloads them. This document inevitably looks better in the court system than it does to us. Downloading them from the state is a TIFF file. I'm not fucking joking. You cannot download them as PDF. It's ridiculous. So this is not that the lawyers can't copy and paste. This is the way the state makes them available. It's awful. In a press release issued the following day, the state announced that it planned to charge Baldwin with 2 counts of involuntary manslaughter plus a sentencing enhancement for the use of the firearm. The press release stated that the firearm enhancement makes the crime punishable by a mandatory 5 years in jail. That would have been true if the firearm enhancement was legal. The firearm enhancement wasn't legal. The press release did not explain why they had chosen to announce the charges before they were actually filed. No, it didn't. Contrary to the solemn occasion, without media appearances, the DA and special prosecutor immediately appeared on national television programs. This is just taking shots at them, but they're also suing them in both their official and personal capacity. So, Plant Hoarder in the chat said, Spyro, don't come at me and write another letter. It wasn't him. I'm not criticizing your screenshot skills. EDB probably. Spyro's not screenshotting this at all. One of his paralegals is. And what we're not doing is ever coming for the paralegals. They do God's work. Law doesn't run without paralegals and court reporters. So they immediately went on the TV. Less than an hour after the DA's office announced its decision, they appeared on CNN to discuss Baldwin's responsibilities as an actor and a producer with respect to firearm safety on the Rust set. Yeah, which was wild. As a representative of the state, the elected DA asserted Baldwin, quote, didn't do any of the things he was supposed to do to make sure that anyone around him was safe. He should have checked the gun, checked those projectiles. This was a lot. And that as a producer, Baldwin had a duty to make sure the set was safe, should have been aware that the safety was an issue. These statements were neither true nor necessary to any legitimate law enforcement purpose. The same day, the DA discussed key pieces of evidence with a reporter from the Santa Fe New Mexican, and she appeared with Andrea Reeb on Fox News stating that it was not a safe set. Okay, well, I don't disagree with that statement. I think that's res ipsa loquitur. Like, the thing literally speaks for itself. Like, literally speaks for itself. Asserting that it was Baldwin's responsibility to ensure set safety. And I can understand their issue with that because at the end of the day, it's truly the AD's job. In the same interview, the special prosecutor stated that a lab report had confirmed that definitely the trigger was pulled. She made baseless assertions about Baldwin's mental state, including that Baldwin knows everything that goes on set, including concerns that others had brought to management. They omitted that the lab report referred to testing in which the FBI broke the firearm by hitting it repeatedly with a mallet. I mean, okay. So they're saying the issue is that they didn't give the public all the information. They also failed to mention the informal testing that the DA's office had conducted, which demonstrated that a single action revolver can discharge without the trigger being pulled. In another January 19th interview with NBC News, the special prosecutor commented on Baldwin's guilt, stating that he is someone who committed a crime. Notice when you see, particularly like the head U.S. attorneys of offices, they talk about these are allegations. In their press releases, it said these are allegations. No one has been committed. These are the alleged crimes. You don't see prosecutors before a trial saying this person committed a crime. You will see them saying, we believe we have the right person. We believe the evidence will show that these charges are why we brought them. Okay. They also say that the elected DA asserted conclusions about the evidence. Quote, we know from the FBI report that he pulled the trigger. I remember when that came out in the media. They go on to say the same day, Brian Carpenter, an expert witness hired by the state, who would later perjure himself before a grand jury, appeared on Fox News to vouch for the prosecution team as being unbiased and having done an excellent job. What, by the way, so weird to have an expert working in the case, giving media interviews before it goes to court. The state later disclosed that Carpenter billed the state $800 for each day of such interviews. Sus. Don't like that at all. That's not part of your official capacity as an expert witness. To give testimony, yes. To give interviews, no. On January 21st, 2023, Special Prosecutor again appeared on Fox News, where she commented on the contents of the FBI report and Baldwin's prior statements, noting that all those statements would be admissible and that would be used against Baldwin. Do I take as much issue with this? I mean, weird. Prosecutors being like, all statements will be used against you. Yep. In those national media appearances, she and the elected DA repeatedly stated that Baldwin was facing many years in prison. I mean, at that time, do you define 5 as many? I mean, at the time, he was facing that much time. I mean, they were wrong in the way that they charged him, but that at the time, he was facing that much time. As the state engaged in further misconduct, the prosecutors sought an improper enhancement of the charges against Baldwin. I don't know if they can be sued for this or not. I'm curious to see how it goes. It just seemed stupid. On January 31st, 2023, the state filed an information charging Baldwin with 2 alternative felony counts and the gun enhancement. The information and accompanying statement of probable cause accused Baldwin of criminal involuntary manslaughter based on 2 theories: his role as an actor and shooter, and his role as a producer. They did do that. As an actor, the statement of probable cause faulted Baldwin for letting the armorer leave the church against protocol, not dealing with safety complaints on set. I think that's got to be a typo. I thought these were the producer complaints, but okay. Not making sure the protocol for safety meetings was occurring and not using a replica for the unscheduled rehearsal without an objective basis to conclude that Baldwin had such authority. As a producer, the statement of probable cause asserted that Baldwin was in a position to manage, oversee. And this is, I picked about these prosecutors at the beginning, but if that's the issue with him as an actor, none of that says that he didn't handle the weapon safely, which is clearly the simplest argument. They go on to say, as a producer, he was supposed to manage and oversee the set and Gutierrez Reed. However, explained above, Baldwin did not oversee the day-to-day production. We've seen that. On the same day it was that it filed the information against Baldwin, the state announced charges against Dave Halls, the self-described, quote, last line of defense, who has publicly expressed that he bears some responsibility for Helena's death. The charges, quote, negligent use of a deadly weapon, a petty misdemeanor that carries a maximum sentence of 6 months in jail and a fine of up to $500. Halls pled no contest and agreed to a suspended sentence and 6 months of probation pending approval. Unsupervised. I hated everything about this plea deal. On February 7th, Baldwin moved to disqualify the special prosecutor because of her dual service as a member of the legislature and a special prosecutor that violated the separation of powers of the New Mexico Constitution and the federal Constitution. It was so weird that they appointed that special prosecutor. Again, was this like, hey, bestie, so I know you were the elected DA and now you're going to be a legislator. Cute, you know, go L. But I think if we bring you in as the special prosecutor, like my district will just pay you like $600,000. Do you want a job? Like, wouldn't it be cute? We'll get to work together, right? Sweet. Like, how did this go down? I don't like in dealing. at all. Also, pick someone in the district. Or just ask another district attorney's office. I just hate it. I hate it. I feel like there were lots of other ways to do this. This was not the right way. I found this motion well taken. And so did they, because then she voluntarily left. But that was, they made a statement in there somewhere. At some point, the special prosecutor made a statement that they would not be intimidated by New York City lawyers or some shit. It was wild. No, I don't know if they put that in here. Baldwin continued to file the motions. On February 16th, the special prosecutor emailed Baldwin's counsel demanding that he withdraw the motion and threatening sanctions for its filing. She emailed him again. This is the tea that I wanted. She emailed him again shortly after stating that she hadn't actually evaluated this issue because she was too busy serving in the legislature. Right. You can't be both arms of government. There's a separation there. There's a reason for it. Then just 3 hours, what they say, she hadn't actually evaluated because she's too busy. I'm too busy. Also, when the elected DA is saying we need a full-time person assigned to this, that full-time person can't have another full-time job. I'm just too busy. I'll review it soon. Then just 3 hours after the first email, she emailed Baldwin's counsel admitting that she 100% agreed that charging the firearm enhancement violated the ex post facto clause of the Constitution. But when the state filed an amended information without the firearm enhancement, it did not attribute the amended information to its filing of an unconstitutional charge, but to avoid further litigious distractions by Baldwin's attorneys. She's wrong on all of that. Similarly, after responding to the disqualification motion, she announced that she was stepping down from her role as special prosecutor, issued another public statement, and characterized her choice to step down as a way to avoid questions regarding her dual roles clouding the real issue at hand. Not content to leave it there, she again commented on Baldwin's ultimate guilt, remarking, "The best way I can ensure justice is served in this case is to step down so the prosecution can focus on the evidence and the facts which clearly show a complete disregard for basic safety protocols. Led to the death of Helena Hutchins." I don't disagree. I think the set did show a complete disregard for basic safety protocols from like a fuck ton of people. Not to be confused with like a metric shit ton, but like a fuck ton of individuals. I don't agree. I don't disagree. Should she have been making that comment? We'll see. Should she have ever been the special prosecutor while also serving in the legislature? No. Did I really want to see the court address that nerdy question? Yes. But she stepped down. So they go on to say that the special prosecutor Reeb at that point had accomplished her goal. She won her election, assumed elected office. On March 15th, 2023, she withdrew as special prosecutor. On March 29th, the elected DA also withdrew after a hearing at which the judge challenged the elected DA's ability to remain alongside any special prosecutor under New Mexico Statute 36-1-23.1, which allows for the appointment of a special prosecutor only when the district attorney cannot prosecute a case for ethical reasons or good cause. Second prosecution team, led by Kari Morrissey, also violated Baldwin's rights. So now we've gotten up to the Morrissey team. In March 2023, the elected DA appointed Kari Morrissey to lead the prosecution. At this point, the deal with Dave Halls is already done. Morrissey's not responsible for that one. That was those who came before. On April 13th, Baldwin's counsel met with Morrissey. God, don't y'all want to know what Bouillon and Jason Lewis have to say? Because damn, do I want to hear from the two of them. In hopes of persuading them that the state's case against Baldwin was unjustified, after the presentation, Morrissey agreed to dismiss the case without prejudice. Remember, that means you can refile it. She acknowledged the prior prosecution's producer theory lacked merit, given that there was no such thing as vicarious liability in criminal law. When the state's firearm experts issued a report questioning the state's theory about the condition of the revolver, prosecutors hid the report. We have gone through this a couple times because it has come up more than once in the Baldwin prosecution. So, Beth Snow asked a question in the chat. Beth, great question. Great question, love to tell you. Beth said, I don't understand why the firearms enhancement in this case was illegal. The firearm enhancement was not a law in effect at the time the incident happened in 2021. So the argument from the defense was that you can't pass a law later and reach back in time and prosecute someone for doing something that doesn't fall within the law at the time that they did it. Some laws are passed with retroactive implications, some are not. But this law did not have any retroactive implication. And when laws are passed, the retroactive implication opens up rights, not closes off rights, like opening up a statute of limitations, like saying, okay, now weed's legal, so we're going to expunge the records. If you were prosecuted under this, it's no longer illegal, so we're going to go back. Even though it was illegal when you did it, we're going to go back and expunge it, those kinds of things. They were trying to reach back and say, at the time you did this, it wasn't illegal. Now it's illegal, so we're going to go back in time and pin you for it. So that's why they couldn't add, on a very basic overview, why they couldn't add the firearm enhancement that wasn't in effect at the time the incident happened. So that is why they could not, it was improper for them to add it. They're arguing it here, saying it shows you that the prosecution was just like, get it, get it, get it, get it. So that is what's going on here. Shortly after dismissing charges, Morrissey retained firearm experts Lucian and Michael Hagg to interpret the FBI. We're getting a lot of use out of that today. The FBI's findings about the prop gun and conduct further analysis. One of those reports wasn't turned over. We went through this ad nauseum. The first Hagg report was turned over. The second Hagg report, I think it was the third one, not turned over. The Haggs issued a third report on August 31st, 2023. The purpose of the third report was to identify the origin of unexplained tool marks present on the working surfaces and sides of the evidence trigger/sear, and to determine whether they existed when the gun was on the rust set. The third report undermined the conclusion of the earlier Hagg reports. It concluded that it is unlikely that these tool marks are the result of the damage incurred during the FBI's impact testing, and that they did not appear to be original manufacturing marks or abuse tool marks based on their irregular orientation. Although the state promptly disclosed the first report to Baldwin, the state failed to disclose the second report and the third report until months later, and months after Morrissey had obtained a grand jury indictment in which she concealed the third report from the grand jury and presented it with only a select set of Hagg's opinions. She didn't present the reports. Hagg testified, is what they're saying. The trial court attempted to stop Morrissey from rigging the grand jury process against Baldwin. There were many motions that we covered this. And there were many motions. On October 5th, 2023, Morrissey told Baldwin that she intended to present the case to a grand jury because she has to in New Mexico. Shortly after, the New York Times published an article revealing that Morrissey had conducted an interview with the Times about the case in which she improperly disclosed details about her intention to present the case to a grand jury. By the way, this was wild too. When this came up in other motions, I was just like, what the fuck? Oh, Beth, you're welcome. The article, not in that context where it could subject you to punishment. The article explained the prosecution's view that the evidence that the evidence about the gun, quote, contradicted Baldwin's assertion that he did not pull the trigger. This was wild. And this happened like after the court was like, what's going on? When seeking an indictment from a grand jury, a prosecuting attorney is required to alert the grand jury to all lawful, competent, and relevant evidence that disproves or reduces a charge or accusation, or that makes an indictment unjustified, and that is within the knowledge, possession, or control of the prosecuting attorney. They still take issue with this. The court has evaluated this multiple times. The court did not take issue with this. They are still taking issue with it, but this has been thoroughly evaluated by the court, in my opinion. And the court was like, this is a nothing burger, so we're going to move through it. Morrissey presented the defense statements to the grand jury like she was supposed to. So again, I covered this in in multiple streams. So if you want more information about the grand jury, there are multiple streams because this was litigated pretty thoroughly. On November 14th, 48 hours before the grand jury was scheduled to begin, Baldwin submitted an alert letter to the state that identified several key witnesses and dozens of documents that would disprove the charges against Baldwin or otherwise make an indictment unjustified. That was presented to the grand jury. They say that the prosecution did not present those witnesses. The prosecution says, we told the grand jury these witnesses were available if they wanted to hear from them, and presented what they would say. Again, this has been litigated thoroughly, like thoroughly. They're going to be bringing it up, and I'm sure they're going to tie it back to the fact that they say the state did not present a fair proceeding. On the January 11th order from the court rejected the state's narrow view of what it means to conduct a fair and impartial grand jury. The court ruled that all 6 of Baldwin's proposed witnesses must be made available to the grand jury, as well as 20 out of the 21 documents the state sought to exclude. And those were made available, it's my understanding, based on the court's finding later. Despite the trial court rulings and in violation of her duties and New Mexico law, Morrissey misled the grand jury. Driven by disdain and a desire to humble an arrogant prick, as she would later refer to Baldwin, Morrissey was determined to secure Baldwin's indictment at any cost. This has been litigated. Same allegations that we've seen in the other litigation. Again, the court, this was litigated in front of Judge Summer, and Judge Summer did not find anything improper. They go on to say the state presented false and incomplete grand jury testimony from lead investigator Hancock. This was litigated as well. I think Hancock's testimony at the trial is a bigger problem. This is cut and pasted from these motions that we've already covered. The state presented false and incomplete grand jury testimony from firearms expert Michael Hagg. Again, litigated. You do you. Good to see you. You do you. Said sending hugs from Cape Town, South Africa. My first live in forever. Glad to see you. Glad you're here. We're zooming through the duplicative stuff. The state presented false and incomplete grand jury testimony from Brian Carpenter. These are going to be the same arguments. Judge Summer has already heard. I think we watched hearings on this or a Zoom court on this as well. The state presented false and incomplete grand jury testimony from Lane Looper and Ross Adiago. And the state kept grand jury from hearing testimony from witnesses that would have undermined an indictment. So all of these pages are relitigating motions that have been litigated before 2 different judges. I want to see how they're going to tie this back. Now Spyro is doing a Morrissey. But wait. But wait. They argued this in front of Judge Summer, and Judge Summer was like, no. After fraudulently obtaining Baldwin's indictment, the state violated his constitutional and statutory rights regarding evidence the state possessed. This is going to get into, hey, you have to turn over all the evidence. And we know that didn't happen. They say over the next 5 months, the state intentionally failed to comply with discovery obligations. It delayed its disclosure of important evidence for weeks and months after receiving it, or failed to disclose it at all. It failed and refused to respond to inquiries from Baldwin's attorneys, and evidence about evidence and the state's disclosure obligations. Even worse, they say the state lied to Baldwin and to the court to cover up what it was doing. All of this undermined Baldwin's right to a fair trial as protected by the United States Constitution and New Mexico law. This gets into all of the discovery issues. Again, this has been litigated over and over and over again because the Hague reports didn't get turned over. The Teskey rounds didn't get turned over. There was more that was heavily redacted and then was supposed to be unredacted. Not everything got unredacted. There was a lot. On May 6, 2024, the deadline to add new witnesses and barely 2 months before trial, Morrissey disclosed to Baldwin's attorney several email communications with one of the DA's expert witnesses, Carpenter, concerning the case that had occurred more than a year earlier. In one of the emails, Morrissey points Carpenter to photographs that, in her words, showed the stark difference between the hammer notches on the gun that Baldwin was given on the Rust set and the notches that appear on a brand new hammer from the exact same gun. In response, Carpenter stated he cannot see any reason that's functionally necessary or does not compromise the safety and integrity and or operation of the gun. He followed up the next day stating, though I see no reason operationally why that modification exists, it remains to be seen definitively if it compromised the safety and function of the revolver. Morrissey retained the Hags to offer their opinions as to the condition of the gun. And we've seen that later. 2 weeks later, on June 6th, after the pretrial interview period had ended, the state disclosed additional communications with the Hags, which is bullshit. All of it should be disclosed before you interview them, or the court should allow a re-interview. So more than 200 files disclosed later that showed the Hags had prepared a third report. Morrissey gave no explanation why it took until June 6th for the state to disclose these materials. Yes, she did. Unless I am grossly mistaken. Again, possible. When the state responded to all of this in the hearings that they had about discovery, she said she thought it was in the discovery portal. And it took a while to realize that it wasn't in the discovery portal because she said it was in the discovery portal, so the defense attorney should have had it. It seemed that there was an issue between the first prosecution and the second prosecution and what was in the discovery portal and what wasn't. Auto Doctor 911 said, Emily, when you say this has been litigated, does it make it less relevant to the action here? No, it's just, I've already covered it so much that they are laying all the groundwork for the causes of action they're bringing. They're like, the prosecution did this, the prosecution did this, the prosecution did that. But judges have ruled on some of this and found that in some instances, the prosecution was not wrong. And in some instances, the prosecution was. But when I talk about it being litigated, part of it is I'm not going through another 15 pages of this because we went through all of the filings and court on it. So we know, but some of it will come up because some of this has been found by the courts that it wasn't an issue, depending on how far we get with this. But Morrissey was like, I thought it was there and then it wasn't. And then, which was a problem. On May 23rd, Morrissey disclosed dozens of audio recordings of interviews that the state's investigator, Connor Rice, had conducted over the prior year. Among them was a 25-minute interview of Andy Graham, a camera operator with firsthand knowledge of the conditions of the Rust set, in which Graham states, among other things, A, he did not think Baldwin's behavior on set was unusual for an actor of his experience. B, actors do not commonly inspect prop firearms. C, an actor should never have to worry about a gun being handed to him loaded. And D, he thinks individuals other than Baldwin should be held responsible for Hutchins' death. Despite this, the state never listed Graham on its witness list, nor did they disclose the recording of the interview until after the May 6th deadline for witness disclosures, which sucks. It might not be that the state uses him as a witness, but if he was interviewed, you have to turn it over, especially when he says he thinks other people other than Baldwin should be held responsible. And if he said that this is not what actors do, that's exculpatory. Like, that's all Brady. Even if the state's not going to call the witness, you still have to turn it over. They go on to say, despite Baldwin's numerous requests for text messages and other communications from important witnesses that were in the state's possession, he had to wait months before the state finally disclosed them. Once they were disclosed, it was clear that the state had been withholding text messages involving key witnesses that were extremely favorable to Baldwin's defense. The state waited until May 14th, 2024 to disclose dozens of previously undisclosed lapel videos. Dude, it's body cam. That depict, among other things, the search of PDQ. Like, what? The state's failure to disclose these materials sooner, while continuing to make arguments that clash with the documented views of its own expert, was all the more disturbing based on the state's refusal to cooperate with Baldwin's efforts to make sense of the state's disclosure methods. Look, I don't disagree with why they're mad. Sometimes discovery doesn't always get turned over in the most organized fashion, but when you have it, you turn it over. And if you do not know if it's all been turned over, you audit it and see if it's all been turned over. And if you're not sure, you turn it over again. This is not civil litigation. This is not criminal defense work for Morrissey. There's no gaming here where there shouldn't be. I'm not saying there's no gaming here. There should not be any gaming. There is no gamesmanship with regard to discovery. You have it, turn it over. If you're not sure, check. And even if you are sure, you should probably check again. Because if you fuck this up, it's a huge problem. You know, constitutional rights and all. So yeah, I don't disagree why the defense has every right to be pissed. This is not how this goes. This is not how any of this works. This is not civil litigation where gamesmanship does get up to fuckery, but this is not that. This is a criminal prosecution. Defendants have rights. Whether or not you think the defendant's an arrogant prick, defendants have rights. That's all. Period. They say the state engaged in haphazard and careless disclosure methods, such as uploading materials to a shared drive without notifying Baldwin what, when, and where new materials were being uploaded. This made it impossible to determine when and what, if any. Damn it! When and what, if any, new discovery the state had disclosed. This problem persisted for many months despite repeated written requests from Baldwin's attorneys that the state provide a workable method for identifying newly disclosed materials that the state was uploading to the database. This would be incredibly frustrating. Just imagine you're an attorney and you have a drive and stuff is just getting uploaded into all of the subfolders and you have no idea if stuff's been added to the subfolders. That does suck. And this case, the argument over discovery went on and on and on. It's as simple as saying, like, hey, here's a list of what we disclosed, or just putting it in a new file and not organizing it. Put a date on a folder and put all the shit in the folder. This shouldn't be hard. I hear a kiddo home from school. On April 30th, have we been streaming that long? Oh yes, 4 hours and almost 15 minutes. We have been streaming that long. Don't worry. Should have broken this up into 2 streams. Sure should have. That's okay. It's all timely. We're getting to it anyway. On April 30th, following the pretrial interview of Hag, in which the second report was disclosed for the first time, Baldwin's counsel sent Morrissey a detailed email about specific files that were missing and Baldwin's overarching discovery concerns. His counsel proposed a new system of disclosure intended to eliminate the gaps and confusion going forward, noting, however, that this system does not resolve our ongoing concern that there appear to be materials that are not timely provided or provided at all, and that the defense ought to have or ought to have been disclosed. The email of what the fuck discovery. This has all been, again, the court kept telling the prosecution that they needed to disclose things, and the prosecution was admonished at one point. that they needed to get everything turned over. And that's part of what Erlinda Johnson did when she came onto the team, was try to fix all the discovery issues. That was like her role in coming in, or one of her roles in coming into this. So this is still over the issues with discovery, the failure to turn over Brady material, the failure to turn things over in a timely fashion. It was discovered after Baldwin's trial was dismissed, or as it was getting dismissed, that there was a whole video interview of Seth Kinney that had never been turned over. Like, this was ongoing. In response to Baldwin's first request, Morrissey stated that Baldwin has received everything pursuant to 5-501 NMRA. This is a problem because this was the disclosure. Morrissey said, you have everything. And it was discovered repeatedly after that that they did not have everything. As of June 10th, the state had not produced Baldwin's counsel a single note of a single conversation with a single witness by a single prosecutor or investigator employed by the DA's office in the 2.5 years since the investigation had began. Not all the notes get turned over. All the reports do. In a response to Baldwin's third request, Morrissey asserted, notwithstanding all of the issues above, that all Brady Giglio materials were provided to the defense on March 28th, 2023. That wasn't true. On June 27th, with the trial fast approaching, Baldwin's counsel sought to confirm Morrissey's implausible assertions that she had fully complied with the state's discovery obligations. Again, Morrissey said again and again and again, you have everything. Baldwin's counsel separately emailed Morrissey's colleague, Erlinda Johnson, a former federal prosecutor who believed in the importance of following the state's disclosure obligations. Yes, she did. A request to make a specific demand for materials from within the materials the government had redacted. And Johnson went through to review it and provide communications. And Johnson turned things over. Johnson stated, with respect to Giglio material, her understanding is that the request for material was made and that the response was received, and that she would inquire if anything is still outstanding. Within mere hours of Johnson's email, the state began disclosing previously undisclosed communications. Right, Erlinda's like, the fuck? So Erlinda comes in, defense is like, Erlinda, can you please check for us? We trust you, Erlinda. And Erlinda was like, oh, fucking hell. Because then Erlinda disclosed over 1,100 pages of documents that the state had never turned over. That all of the material subject to disclosure under the state rules and had not been previously disclosed. Indeed, Johnson expressly conceded that these communications were required to be disclosed. She's like, yeah, you should have had this. The state had massively violated its obligations, and this is before we even get to trial. In Judge Summers' August 1st written order dismissing the case, the court recognized that the state continually made late disclosures to defendant throughout pretrial litigation, and even in the days immediately preceding the jury trial. The court noted that these violations continued despite the fact, hey T, today was a uniform day? Look good. I like your captain stripes. Congratulations. I'm still streaming if you want to show the Lawnards. What? It's exciting. Your school's not on there though. If you want to say hi. What do you mean? Come here. What do you mean your backpack broke? They can't see you.
I'm just saying home. Yeah, I'm just saying hi. I'm sorry it's a miss.
It's okay.
Yeah. I just got home.
Nobody's judging you.
Backpack broke, so that's all. I'm home. I'm gonna fix it. I'm all good.
Go get food. We'll talk about your backpack when I'm done streaming.
Enjoy. Which case is this?
Baldwin, some more. Fred.
Yeah, Fred.
Take Fred with you.
I told him at like arm's length though. So.
Yeah, don't get cat hair on your uniform.
Yeah, that's the last thing. Come on, George.
Bye, T. I will come find you when I'm done streaming. Chat says hi. He's like, hi, chat. He's like, chat, chat, chat. Chat, 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 chat. What, T? I know people say chat at school to address people. I know. We've gotten to the point where teens refer to their peers as chat. It is a whole thing. What's up, chat? He actually gets to say hi to chat in my chat. Okay. Judy says, I'm 15 minutes back. Can't wait for T to make an appearance. Oh, all right. Buffy said, when did T's voice? I know. He's 16. He's 16. He's grown a lot in the time I've been streaming with y'all. He's like a whole human. He does not think he looks nice in his uniform because his uniform is, he doesn't have all his stuff on because he just got home from school. So he's like, I'm like, nobody's going to clock you in the chat. Don't worry, T. So, but I like it. Cena, I agree. Chat is gender neutral and inclusive. I know when I was growing up, we just used dude to mean the same thing. But yes, I'm not surprised his backpack broke either. I'll go check in with that. Why is T shy? T's always shy. He also, yeah, this is a whole conversation for later, but T's like, I don't necessarily want to be on the internet. So he is learning the joys of leadership at school in ROTC. He's like, it's hard to make teenagers do shit. I'm like, So his uniforms for ROTC, the ROTC program at his school is huge. So yes, he's like, trying to make teens do things is difficult. It's the best. Trying to be in a leadership position with your peers is a very, very interesting thing. So, all right, let us keep rolling. We've seen all these complaints. We've seen the ongoing slew of issues. There were discovery issues. That is fact at this point. There were discovery issues. There were ongoing discovery issues. Erlinda tried to fix some of it, was not able to fix all of it, which is why I think we saw Erlinda be like, fuck this shit, I'm out. My words, not hers, during trial when it became obvious that more things hadn't been disclosed. I can only imagine that behind the scenes, Erlinda and Kari Morrissey didn't always see eye to eye, but I don't know if Kari Morrissey was ever a prosecutor, but when the former federal prosecutor is saying we need to do all of this, just do that. She's not wrong. Like, Erlinda was not wrong. Erlinda was correct. Listen to Erlinda. In Erlinda we trust up in here. And Erlinda was just like, no, I'm not. You have an obligation. And if you're going to overrule me, then I'm out. It's what I say prosecutors should do. It's not easy, but it's what I say prosecutors should do. If you cannot do the thing without violating your ethics, your obligation is to tell the court, quit. And it seemed like Erlinda did both. She told the court and she quit. Not always easy, but I don't know what else Erlinda was supposed to do. It goes on to say that in the court's ruling, and I covered the court's ruling multiple times, the court further noted the state's representation weeks before trial that it had conducted a complete audit of its discovery disclosure files, right, as soon as it was aware of potential problems and had cured any discovery disclosure issues. Simply put, Morrissey intentionally deprived Baldwin of evidence that was required to be disclosed under New Mexico law, and she had repeatedly lied to Baldwin in the court about the state's compliance. That's going to be a problem. Trial revealed the shocking depths of the state's bad faith and scorching prejudice. This is all coming from the court's words. This is coming from the last day of trial. This is coming from Morrissey saying we've disclosed everything, and then stuff not coming forward at all. Morrissey already conceded that the criminal negligence standard requires the prosecution to show that Baldwin had subjective knowledge of actual risk. or handled the gun recklessly. They keep leaving that part out. In securing Gutierrez-Reed's conviction, Morrissey's co-prosecutor told juries that the prospect of live ammunition landing on a film set is incomprehensible. Again, they are saying, look, the prosecution can't argue in good faith that he should have perceived the risk. I get it. Morrissey sought to overcome this burden in two ways. The first was to present a meritless theory that Baldwin was responsible for Gutierrez-Reed's negligence. That wasn't allowed at trial. The court dismissed that argument. They did. The court dismissing an argument, by the way, doesn't mean you can get sued for making the argument. The discovery, on the other hand, is a different can of worms. They go on to say evidence that tended to show that Gutierrez-Reed was not the source of the live ammo, e.g. evidence that ammunition came from an outside source, would have undermined Morrissey's key basis for linking Baldwin to Hutchinson's death. Again, I think it was the negligent handling. They disagree. They're more intricately linked in this case than I am, and they are presenting this in the light most favorable to their client. They go on to say Kinney explained at the time that the manufacturer may have mixed primers when preparing reloads. Hancock agreed, noting that testing at least a few of the rounds would have been really important. Seth Kinney told Teskey that the ammunition was evidence in an accidental death investigation. We did an entire day of court on all of this. Popple identified the opposite when Morrissey knowingly elicited false testimony from her that the rounds did not match those from set. Morrissey maintains on this that she didn't know that it was false testimony because she assumed, which is not good either. Question, let me ask you, Miss Popple, it's like Spyro took all of the motions that they have filed and put them into one civil lawsuit. Just put them into one civil lawsuit. Let me ask you, Miss Popple, the ammunition that the Good Samaritan, Mr. Teskey, a close friend of Hannah Gutierrez's dad, that ammunition that he brought to you after the conviction, you still have it? Yes. You can bring it here and show it to the jury, right? Yes. This is in front of the jury on day 2. Yes. And they can see for themselves that it does not match the live ammunition from the set of Rust, correct? Yes. And that is obvious just when you look at it, is it not? Yes. That was not true. The false testimony was rebutted the next day. As Judge Summer explained, Corporal Hancock testified that CST Popple gave false testimony during the second day of trial. Specifically, Hancock testified that Popple's testimony given in front of the jury concerning the attributes of the collected ammunition when compared to the attributes of the live ammunition from set was false. The state's cover-up crumbled at trial. The state knew the rounds matched. I don't know if the state knew. I truly don't know if the state knew. She should have known. They're arguing she willfully knew because they're suing her. We'll see. The state knew that the rounds matched, that the 3 matching rounds were the first ones lodged in the hidden report, described as having 3 features key. The following items were given to CST Popple. 3 Starline brass 45 Colt silver in color primer brass in color casing. Item 1 in the report. Orlando was right that when this came out, the state should have dismissed. When Judge Summer questioned Popple the next day, she was forced to admit as much. And this was outside the presence of the jury. Judge Summer, all right, let me ask you a different way. Do you recognize any of these types of bullets to have been gathered on the Hannah Gutierrez on the Rust set, the witness? The Starline brass with silver primer are similar to what was collected on set. There was no doubt that Teskey, a witness that the sheriffs knew of, had made clear that the evidence he was providing to them was from the same batch of ammo. The report stated, and we haven't seen this full report, and this document scanned it terribly. I'm going to do my best. We're going to play like connect the dots. Mr. Teskey informed CST Popple that he had, look, the dyslexia is the only thing making this work because my brain's used to working hard for it to be able to read anything. That he had live rounds of ammunition that he believed to be connected to the Rust case. And then they put in the Rust case number. Teskey stated he had ammunition that he believed was from the same batch of ammunition that was located at Seth Kinney's warehouse in Albuquerque. Teskey informed Popple that he had informed Hancock and Kinney about these rounds on November 5th, 2021 via phone. Teskey stated that these rounds originated from Joe Swanson and that he was asked to bring them to court by the defense. The defense, in turn, did not call Teskey to the stand, and Teskey no longer wishes to keep the ammunition. That report should have gone to the defense, and then the state could have argued, okay, but this man's belief that these are the same batch may or may not be true. Fine. Reximoto, I'm sorry to hear that. Reximoto said we had a pipe burst this morning. We are without running water. I am sorry to hear that. Hopefully nothing is damaged from the water and it gets fixed quickly. So that report should have gone to the defense. Even in light of these explicit and detailed explanations, the state still tried to cover its tracks. It argued first that the evidence had been lodged separately because it was not collected at the set. Then it argued that this occurred, because the evidence was not collected by the officers independently. I mean, it was given to them at the station. And finally, the state claimed it was not logged with the Rust case because Teskey had supposedly not returned the state's phone calls. Morrissey doubled down, offered increasingly inconsistent explanations. She initially argued the rounds would have been relevant if they had matched the rounds on Rust, but then argued that they could not have been relevant unless they had been shown to have left the state of Arizona. Further tried to minimize and sanitize the state's actions, attempting to justify the state's failure to allow the defense to view the ammunition, saying, I had never seen it and I didn't realize it wasn't under the same case number because I'm not law enforcement and I don't work for the sheriffs. The court noted this testimony conflicts with Corporal Hancock, who testified that the sheriffs and special prosecutor decided to separately file this evidence apart from the evidence in Rust. There can be no doubt what happened here, the defense argues. The state further deliberately ignored this exculpatory evidence and then, when unable to ignore it further, buried the exculpatory evidence. The state never disclosed the evidence to Baldwin, notwithstanding the repeated demands, evidence viewings, and representations. That is the issue, truly the issue at heart here. After extensive testimony from Hancock, Popple, Brandel, and Morrissey, the court concluded as follows. The state's willful withholding of this information was intentional and deliberate. If this conduct does not rise to the level of bad faith, it certainly comes so near bad faith as to show signs of scorching prejudice. First claim of relief, violation of deprivation of rights, violation of 1983 against all defendants, stating that they violated Baldwin's constitutional rights based on everything we have just gone over, most notably the Brady violations, I think. And then that they all conspired together to do the same. They are alleging the TV interviews in here too. And the ex post facto clause. I think the strongest argument here is likely going to be the discovery issues. But there are other issues that they have pointed to. Let's go to the second cause of action. Let's see. Oh, wait, no. Let's get to immunity. Let's see. In carrying out the conspiracy, this filing says defendants were driven by ill motives and to accomplish illegitimate ends, including to harass or humble Baldwin, to promote their political agendas, or to further their own personal agendas and professional ambitions. Defendants' actions violated the constitutional rights of Baldwin. The immunity typically afforded to prosecutors acting in their quasi-judicial role does not apply to the above actions undertaken by the prosecutor's office because they were performing an administrative or investigative capacity beyond the prosecutorial function. So the defense is arguing that the prosecutorial immunity does not apply here because they were acting outside of those bounds. If you do not watch Quick Bits, don't forget to watch Quick Bits. If you have the Law Nerd app, it just gets delivered to you so you can click Quick Bits. But there is a Quick Bits episode where I cover a judge being civilly sued, and the argument there is similar. Did the judge in his wild day of scaring the crap out of a teenager who was in court and like putting her in lockup and putting her on like a fake trial to like show her for falling asleep in court, was that part of his judicial function or outside of his judicial function? Because he's not on the bench. He's not presiding over a case. He's talking to students about the judicial system. So does immunity cover non-judicial functions? So part of them lining all of this out is saying their non-prosecutorial functions were not taken in good faith. And these are non-prosecutorial functions. So how we define the scope of prosecution, investigation is often going to come into that. But what about administrative? And how is it defined in New Mexico? And what does the case law say? Nothing has come out of that one just yet, but we're going to be checking back in on it. It's on my docket. For all of you that are like, that one made me so mad, same. So they are saying, they are arguing that immunity doesn't apply here. This is going to be litigated a lot, and we're going to get into it. So they are saying that prosecutorial immunity does not apply. This is suppression of evidence and deprivation of rights against the law enforcement officers, which is going to be same. So this is going to be same. And different immunity at play here. Though chat has noted that some of the immunities have been abolished in New Mexico. So let's see. They do not note anything about immunity of the law enforcement officers here. So it's something I will be looking into, but they do not note immunity with regard to law enforcement. So they are saying law enforcement did not take actions in good faith, that their actions violated the law and deprived the defendants of his rights, constitutional rights. Specifically, third claim, malicious abuse of process, Hancock, Popple, Brandel, and the county. Not Morrissey. That Hancock, Popple, Brandel, while acting within the scope of their duties, deprioritized investigating the source of live ammunition. They tried to disprove Baldwin's. They presented a case. They presented false testimony. It's going to be, we'll see where the argument lands on that, but they are arguing the testimony presented and the burying of the report goes into that. Spoliation of evidence, Hancock, Popple, commissioners in the county. I don't know if it's because the commissioners in the county approved the money, but this is about sending it to the FBI and the FBI testing. No, they're not suing the FBI. They are saying the immunity granted under 4144 does not apply to liability for personal injury resulting from intentional spoliation of evidence. I don't know if destructive testing is going to count as intentional spoliation of evidence. We will see. This will be litigated, but they are citing the code sections that would allow you to sue outside of immunity for the intentional spoliation of evidence or the deprivation of rights. Interesting to me that it wasn't in the other section, but okay. Defamation per se. Again, no Kari Morrissey in this. All right. This is defamation per se against the first special prosecutor and the elected DA. The defamatory statements include without limitation the following. Let me know what you think. January 19th, the elected DA appeared on CNN discussing key pieces of evidence with a reporter from the Santa Fe New Mexican and said Baldwin had a duty to make sure the set was safe. Defamation per se can include talking about someone's ability or inability to do their job. Is this what they are trying to pull that under? Saying, hey, Baldwin, you're saying Baldwin did his job as an actor wrong? Saying that he should have checked the gun and checked the projectiles? We'll see if that's defamation per se. I mean, are we stretching to this is talking about his inability to do his job well? I don't know. What code section do they say this is under? They don't. Which, I have questions. Which New Mexico code? Oh my God. Nope, they don't. All right. This is I'm going to look at this a bit more. So we'll probably talk about it later this week as an addendum, like asterisks. I'm very interested to see what defamation per se in New Mexico says about workplace. Let's see if I can find it real quick, because now I'm curious. Let's see if we can find a very quick statute. That's the statute of limitation. Let's see. 4171. Let's see. This can include, it looks like on a very quick look, unprofessional conduct. So under defamation per se, unprofessional conduct, we've covered this in Georgia and we've covered this in Idaho, but in unprofessional conduct, I think is where they're getting at with the defamation per se. So January 19th, let's see, should have checked the gun, should have checked the projectiles, was responsible for Helena Hutchins' death. We know under defamation per se that in most states, alleging that someone has committed a serious crime is and can be defamation per se. Are they alleging that Baldwin committed a serious crime? I think so. What's going to be difficult with this is to get to the bottom of this defamation suit. If this goes to trial, are they going to have a whole trial on liability? Because the criminal case did not resolve whether or not Baldwin had a duty, whether or not Baldwin is criminally liable. Because under the involuntary manslaughter, negligent handling of a weapon can get you to involuntary manslaughter. But it got yeeted by the judge before that question was answered. So how do you answer if this is defamatory or not if it's true? Because we didn't get an answer about whether it's true. So Caitlin, hey Caitlin. Caitlin says, watching this while in labor with my first. Caitlin, I hope your labor goes smoothly. Remember to rest. Here is the best advice I can give any new parent. Babies do not see sleep on like a 12-hour clock. They treat everything on a 24-hour clock. I know it is hard when people say rest when baby rest, but you have to rest when baby rest. Babies treat everything on a 24-hour clock, and babies often sleep when you are most active. So their sleep schedule and your awake schedule are synced together. That does not change when they are born. They are asleep when you are most active. So when baby rests, you rest. No matter how hard it is, when baby rests, you rest. Because your sleep is now also going to be on a 24-hour clock. That means at night you're going to be awake, during the day you're going to be asleep, until everybody gets back onto a sleep sync. But give yourself lots of grace. Sleep when you can. Sleep when you can, because you're going to get 3 hours here and 4 hours there and 2 hours here and 90 minutes over there. And it just is. Do not try to get other stuff done when baby is awake. When baby is awake, Put baby on you, take baby with you, do the things you need to do. Sleep when baby sleeps. Do not try to get shit done when baby is asleep. Just, baby's used to being calm when you're moving around. That is my best advice for you. Congratulations and good luck. Also, if people ask to help, let them bring you food or give you gift cards for DoorDash. All right. Maddie Flap said, Emily is still live. I'm trying not to be. Oh my God, almost 5 hours. Emily, you really should stick to the one topic per stream so we don't stream for 100 years. But here we are. So the defamation per se, they are getting to whether or not Baldwin, or whether or not they alleged Baldwin committed a crime or behaved unprofessionally. This might end up with an entire sub trial of whether or not Baldwin did the thing, right? Isn't that what really Depp Heard boiled down to? Is this defamatory because did the thing happen? And it was a whole sub trial of the thing. And then is saying that defamatory? That's where we're going to end up in this. If the defamation goes forward, a whole ass trial over, okay, but are they accusing him of a crime or did he commit a crime? Which is going to be a trial within a trial on defamation. It's going to be a whole thing. So again, all these statements that they're pulling out are statements that go to crime and unprofessional behavior as an actor. And these are all the different things we have seen. They are rehashing everything we read above. So we are zooming until we get to the end of that. This one has both of them in it. Let's see. The special prosecutor issued a public statement saying, the best way I can ensure justice is served in this case is to step down so that the prosecution can focus on the evidence and the facts, which clearly show a complete disregard for basic safety protocols led to the death of Helena Hutchins. I mean, I think that's true. It's whether or not that's insinuating Baldwin. They say these statements made in connection with Baldwin's case carried the implication that Hutchins died because of Baldwin's criminal misconduct. They're going to argue that obviously if basic safety protocols were filed, nobody dies on a movie set in this way. That's what they're going to argue. This is not an easy road. We're also adding in a public figure and a matter of public concern. So there also is going to have to be that level of actual malice. And the prosecutors are going to say, we believed we could prove this beyond a reasonable doubt. So whether or not prosecutors should say this stuff in public or shouldn't say this stuff in public or should say it before a prosecution or not, at the defamation core, you're going to have to look at, or the heart of the defamation case, not like defamation core. At the core of the defamation case, you're going to have to look at, did they believe? No, not did they believe. Did they know and disregard the truth that Baldwin didn't do these things? Because that also goes to prosecuting someone when you don't believe you can prove it beyond a reasonable doubt. They're going to say, we believe we can prosecute him beyond a reasonable doubt. We believe these things are true. He's a public figure. There's no actual malice here. So we're not disregarding the truth. We're seeking the truth. So that's going to be the argument there. We'll see. I'm interested to see how immunity plays into all of this, truly. They say the immunity typically afforded prosecutors acting in their quasi-judicial role does not apply because making statements to the news media were not in the scope of their authority as prosecutors. Is making statements to the media about a case that you're prosecuting inside or outside the scope? All of that's going to be litigated before we get to figuring out any of the issues here. violation of New Mexico civil rights against the DA's office, the commissioners, and the county. Let's see. This is for not limited to the following acts. The motive of disproving Baldwin, testing the gun, the ex post facto clause, everything we've seen above. I'm going to go back through these real quick because I want to see exactly which ones they've got Morrissey on. Sorry for this. Zoom. Okay. Only the first cause of action. The deprivation of rights. The first cause of action is against all defendants. Cause of action 2 is against law enforcement only. Hancock, Popple, Brandel. Cause of action 3 is against law enforcement only. Well, law enforcement and the county. Cause of action 4 is law enforcement, the county, and the commissioners with the spoliation of evidence. Cause of action 5 is just the elected DA and the prior special counsel or special prosecutor. And cause of action 6 is against the district attorney's office, the county, and the county commissioners. So Morrissey's only sued in one count of all of this. I'll be interested to see how we navigate through the extensive red tape of suing government entities. It's something we haven't covered before on the channel. And I hope you're interested in it like I am, because let's see. I'm going to see if they get to immunity. Immunity granted by Section 41(4)(a)(4) does not apply to liability for the deprivation of rights caused by any public body or person acting under color of law within the course and scope of the authority. Immunity afforded to prosecutors doesn't apply here. We've got a lot of immunity issues we're going to talk about. Hopefully you are interested in government immunity, prosecutorial immunity, police immunity, but the pre-trial litigation over immunity is, I think, going to be quite interesting. So, Tori asked, do I think this gets past a motion to dismiss? Motions to dismiss are four corners. I think they've alleged grounds for all of this. I'm interested to see how the litigation happens with regard to immunity. So that's what I want to see. Prayer for relief, awarding general and compensatory damage, punitive damages, prejudgment interest, lawsuit, jury trial, signed January 9th, 2025. Look, let's try to do a summary real quick. I'm going to get to some questions and then we're going to break because now I'm hungry. Well, of course I am. It's 4:00. Tomorrow, I'm not going to promise anything about tomorrow's stream. I'm going to say like, let's just do a shorter stream tomorrow. And then tomorrow, all of you are just going to be like, lol. All right, let's see if we can summarize this and get to some of your questions. We'll do more questions tomorrow too. We will leave more time for questions. After going through the 73 pages of Baldwin's lawsuit against Kari Morrissey and others, interestingly, Kari Morrissey is only sued in one of the 6 causes of action, with numerous causes of action against the elected district attorney, the prior special prosecutor, and multiple members of law enforcement. This motion read like Quinn Emanuel, Spiro, and the other attorneys from Baldwin's criminal team took all of their litigation from the trial and cut and pasted it into a civil lawsuit. They brought up all of the discovery issues that we've seen across multiple filings in litigation in the trial before it went to trial. They brought up the complaints that they had previously about how the grand jury was run, what Kari Morrissey did at grand jury, how Kari Morrissey went forward with a grand jury, which, again, arguments that they made in front of Judge Summer, and Judge Summer said, no, Kari Morrissey did not do anything wrong with regard to the grand jury. So some of these things have been litigated in motion in the trial court different than bringing them up as civil violations of Baldwin's rights. It will be interesting to see when you have a judge ruling against the defense in a lot of these areas, how that will lay the groundwork for these deprivation of rights causes of action. But what's interesting there too is that ultimately Judge Summer dismissed the case against Baldwin for prosecutorial conduct. The court said, look, if this is not bad faith, it's as close as we get to bad faith, with the prosecution not turning over evidence. So is that alone going to be enough to lay the groundwork here? And then even though the individual motions were denied, that lays a pattern for the deprivation of rights lawsuit that's being brought here, and the defamation lawsuit, which is grounded in defamation per se, but this is going to be defamation per se against a public figure, which can be more difficult. It seems the grounds of defamation per se that Baldwin is attacking under is in the realm of unprofessional conduct and accusing someone of a crime. If the defamation case goes forward, we could end up in a position where the defamation case is necessarily going to litigate whether or not Baldwin was reckless with a firearm on set in a way that could have led him to be convicted for negligent manslaughter, even though the jury didn't decide that. The judge never decided that Baldwin was guilty or not guilty. The question of Baldwin's guilt of negligent manslaughter was never decided. The question of the prosecution's failure to turn over evidence is what was answered by the court's dismissal. So could we end up in a defamation lawsuit that ends up feeling like a criminal trial? Maybe. So I anticipate quite a lot of litigation here because we are going to see arguments over immunity for the prosecutors, for law enforcement, for the county, and for the commissioner board. And we are going to see then litigation about how we get into defamation when prosecutors are going to argue that they believe they could prove this beyond a reasonable doubt. You could end up in a situation, or we could end up in a situation, where more evidence comes in than would come in a criminal trial because it goes to what the prosecutors knew when they were making statements, not what they would prove at trial. So we will see. But there is one more ruling that we need to look at very quickly that was filed on January 13th that I don't think I've seen reported. It's probably been reported now because I've been streaming for 100 years today. But there is one more ruling. And Miguelina, yes, this is part of my summary. One more ruling. And this ruling from the 13th, yes, January 13th, is from the presiding judge of the First Judicial District Court. Comes now Honorable Brian Biched, acting in his capacity as Chief Judge for the First Judicial District Court and pursuant to the New Mexico Code of Judicial Conduct, hereby recuses all First Judicial Circuit judges from the above captioned civil action. So, on the 13th, yesterday, Monday, January 13th, the presiding judge for the First Judicial District of New Mexico recused every single judge in the district from this case. So all of the judges are out. Every single one. Yep, everyone. I imagine it's because the district attorney's office that all of these judges work with is being sued. The board of commissioners in their district is being sued, and the entire county is being sued. So I imagine that these judges are like, we can't touch any of this. It needs to go to a different judicial district and different judges who do not interact with this DA's office, with the county commissioner office, and with the county itself need to take it up. This is not ours. Send this to a different district. We are not answering these questions. We are too involved. So the judge was like, yeet, send it to a different district. So it will go to a different judicial district when the judge in charge of all of it decides. So with all of that, we need to go to questions. You've got questions. I've got questions. Ms. Tanisha said that's pretty bad, right? No, it's not bad. It's not good. It's the judges saying the entire bench deals with this DA's office, deals with this commissioner, deals with this city. The judges were like, we don't even want a appearance of impropriety. I don't know if the county commissioners, it's normally the state, is involved in judicial salaries at all. I don't know how much the county deals with the bench, but the bench deals with this DA's office day in and day out. So if you're asking the judges to rule against the DA's office in their own district, I'm not surprised the judges were like, nope, this is not us. We don't even want an appearance of impropriety. We are interconnected with these other government agencies. We are the judicial branch of government of this district. Send it to a different district. So I think it's smart. I don't think it's bad. I think it's necessary. And I like that it was just like, we're not even going to bounce this around. We're not going to waste anyone's time. We're recusing everyone. Send it to a different district. I think that's appropriate given the scope of those being sued. A great question. Let's go to questions real quick before I bounce because I am hungry. But it does feel drastic. It does feel like all of the judges are gone. It is drastic, but I don't know how many judges are in the first judicial district of New Mexico, but it's a recognition that it doesn't make sense to make each judge, every single judge in that district would recuse themselves. Why waste everybody's time of being like, Judge A, recused, Judge B, recused, Judge C, recused? Why waste everyone's paper? Just recuse all of the judges. Heather in the chat says 6. Right. None of the judges can take this case. So the presiding judge was like, we're not going to waste everybody's time. So we'll see where it gets reassigned to. All right, we're going to do some quick questions. Emily, thank you. Not a question, statement that I love. The video with Lawyer You Know, the crossover we all needed. I know many of you watch Peter, and we will link that in the description too if you haven't seen our lawyers talking about lawyers like lawyers. I did an episode of his podcast. We had been trying to schedule it forever, and then I streamed late, and then he was like, it's okay, we'll bounce it till later. So we were also kind of punchy. I am Ken Ross said, what's up, chat? Served jury duty yesterday. It was wild. Glad to be home today with the law nerds. Ken, I hope it was a illuminating experience. Thank you for sharing that you got to do jury duty. I hope that being a law nerd changes everyone's mind about jury duty to where when you get that summons, you're like, ooh, this is exciting. I can't wait to see it. This is a great point, Eugene. Could Judge Summers be called as a witness? It's possible. This is also a good point. It is possible. And Judge Summers can't overhear this. So, or hear this. So that is an excellent point. So there are things that Judge Summers might need to be a witness for, but some of that stuff is just, did you make this ruling? Yes. Like at all. Chat, we're going to have law nerd love connections in the chat. I see all of y'all. I love it. Celestial said, fingers crossed for my app release this week. Fingers crossed. I know it can be stressful. Trust it can be stressful, but it's so worth it. I love our app. I love it, love it, love it, love it, love it. I am Kelly and I grow it said, please get a will, living will, power of attorney. Yes, we were talking much earlier about all of the practical, tactical. Matt, the future ASQ, good to see you. Emily, been a bit. School started last week. Already have a 7-page research paper due. Just finished McDonald's. Matt, don't forget, look, hydrate and rest. This is my advice for almost everything, whether you're having kids or going to school, but your brain does not work well when you have not slept enough. Do I take this advice well? No, I don't. But I know that it is true. Your brain does not work well when you do not rest. So if you start the habits in school of taking time to move in some way, like move it in just some way, hydrate with water in addition to libation and caffeination, hydrate, and get adequate rest, your brain will do better. The extra 2 hours of studying are not going to help. The extra 2 hours of sleep will help. You have to sleep. You have to sleep. You have to sleep. Shelly said, my husband got me a Remarkable for Christmas and I'm in love with it. I'm so glad to hear it. I'm so glad to hear it. Tamara said, the question I really want to see, asked if she gets to testify. Can you tell the difference? I have no idea how to pronounce that, of a mesophalic or brachial bite from pattern. I don't know if they will ask, but we will see. I don't know. Julie said, off topic, hope Judge Abby is safe from the fires. Judge Abby is safe from the fires. Fellow reality competition buff, do you watch The Challenge? I have not watched The Challenge, though I have been told it is excellent. It is on my list after seeing how many challenge players I like in Traders. So it's there. Sherbert said, ADB, you're in my head today. First, The Mummy. My Neurospicy rewatch. Hubs call it my documentary. Take that, Bainbridge Scholars. Next, Traders just finished season 1. I love Traders. I also love The Mummy. Emma said, Emily, how did you play water polo and are allergic to chlorine? I was sick all the time. I was sick like all the time. Like all kinds, inflammation, like all kinds of stuff. And some of those things, I have not, like chronic sinus infections and stuff, I have not had issues with that kind of inflammation and issues since I stopped swimming regularly. Now I can see it on my skin and in my breathing. When I pool, I try to salt water the best I can versus lots of chlorine, but heavily chlorinated pools, like I can feel it in my chest now. So let's see. How can it be a Rule 14 violation when the DOJ have to report to both parties? Squirty Belly, this is a great question. And also the reference to the Karen Reed case with Squirty Belly is hilarious. We will see what the judge says, but yes, the DOJ has to turn it over. What do we know about the feds? When the feds have to play nice in state court, they don't always do it. Do the feds always turn over shit to state prosecutors, defense attorneys when they should? No. Do they always turn it over well? No. Is this an issue going on in Idaho? Yes. It's so annoying. But the feds are like, eh. Sarah Liz G said, Emily, 46 years old, got my ADHD diagnosis yesterday, Wales, UK, PS. Cannot wait to watch trial 2 with you in the law nerds. Sarah Liz, I hope it feels like you know yourself a bit better. I find that sometimes you go, that makes sense. And then the second feeling, or maybe the first and then second, is why the fuck did this take so long? Like there's a frustration period too. So give yourself all of the frustration of how did we not get here sooner, but also, it's nice to know. The more you know. B2, thank you for the 20 gifted memberships. Nana Banana 9, thank you for the gifted memberships. Appreciate it. When I said we're going to have members only, I'm going to put dates and times up tomorrow so I don't misstate myself. But we are doing, hold on. No, I'm not. I'm just going to grab my calendar real quick. We are doing a members only live tomorrow. And then we are doing a members only live on the 22nd. So we are going to do 2. They are going to be different. Look, this is just between us chickens. But there is a complaint I get on my channel above almost all else. The first one, well, it happens more in quick bits now, is like, why are you still talking? You're new here. The second complaint I get, we get emails, we get DMs, we get people reaching out to customer service for the app asking, where are the missing days of the Depp v. Heard trial? Where are the missing days of the Depp v. Heard trial? During Depp v. Heard, I traveled to a friend's conference, and there were days that were missed. And it is a source of frustration for law nerds far and wide because people go through to rewatch the trial and there are days missing. There are witnesses I did not cover. There is frustration. So I am going to watch with you the days I missed for Depp Heard on members only, so that when we do a mega stream of Depp v. Heard the way we did for Boone, it's probably going to have to be 2 parts. But when we do the mega stream, we will have all of the days, some of them in hindsight. So for those of you that are not members, do not worry. It will be up on the channel. But I am recording that live as a members only video, and then it will be up on the channel, so you will have it. So we are going to go through it together so that those missing days aren't on there. If you are not a member, don't worry. Those videos will be available afterwards. I'm going to record it live. But if you are not a member, it will still be up. So do not fret. But we will be watching it together. And we will have more than one day of doing this. But next week on Wednesday, I am not going to stream a public stream at 11. We are going to do a members stream. So we are going to do that. So that's what we're going to do on Wednesday next week. The reason I am not doing a live stream Wednesday next week, though we have gone to Tuesday, Wednesday, Thursday streaming, is because there are 2 days of Idaho hearings next week. So I am anticipating covering 2 days of Idaho next week. If we get through just one full day of Idaho and they're done, then that's what it is. If we do not, then we are not. Hold on. Judge Abby is calling in the middle of the day. Let me let her know. Just, she's going to be like, how did you miss my call this morning because of stream and you're missing my call now because of stream? And I'm going to be like, because 5 hours, because of full work day. So next week we have Idaho hearings. Next Wednesday, don't worry, I'll remind you again, next Wednesday, we're going to revisit witnesses together. And then those will be public. If you don't watch it live, don't worry, those will be public. And then as we put together the Depp v. Heard playlist, we are going to fill in the gaps of the days we didn't get to. So Wednesday will be this Wednesday will be a normal members only stream. I have not set the time yet. I will tell you tomorrow, because tomorrow will be a shorter stream. Tomorrow will be a members only stream, early evening, and we'll talk about all the things we haven't gotten to talk about yet. And then next Wednesday will be a daytime members only stream, and we're going to watch some of the things we've missed, some of the witnesses we missed from Depp v. Heard. Let's get to a few more questions, and then I am going to see I'm going to get some food. B, see what Judge Abby's up to. So to everyone who got gifted memberships, we've got lots and lots of member stuff happening. So that's what we're going to do. Glad I'm not the only one who got Nerdy Christmas. Got a Remarkable Paper Pro. Do you love it? I enjoy mine so much. It's just nice. Cully Cullen said, would Halls have been charged without the deal? He was charged. He was charged lower because the deal was negotiated before he was charged. Yes, he would have. He's one of the most culpable people in my mind after everything we've watched. Still is. I don't think my mind can be changed on that. But he spoke early and the prosecutors wanted something from him, including his testimony. So I ran out of water. I learned. I brought backup. I brought Lawnard backup today because I learned last week. Judy G, this is a great question. Judy G said, question, are civil trials like the lawsuits filed against Diddy televised? Just wondering if we will be able to see any legal proceedings or just read about them. It depends on the jurisdiction. Diddy is in federal court. Federal court says, fuck off. Come sit your butt in the seat or don't. So federal court, like Diddy, no. State court, it depends on the state. I imagine New Mexico will have a split interest in this. I think some of New Mexico will want this to be televised. I wonder if some politicians will not want this to be televised. We will see. We will see. Idaho, Kylie said, I've already started my season 4 Traders US Ideal Cast. Top picks so far. Stassi, Rinna, Heather Gay, Theo Vaughn, Nick Vile, Spencer Pratt. Could you imagine if they put Spencer and Heidi both in the house? Like just both? But Idaho Kylie, sorry. I love this. I love this casting. I'm here for the Traitors casting season 4. I'm ready. Cindy said, is there videotape of the measuring of Chloe? We don't know. I don't know what was disclosed. We only heard about it in court. Chickpea said, I'm at Slice and Pint right now. Oh, making me hungry. It's so good. Emily, you don't know about ball peen hammers. I do know about ball peen hammers. It's just once we got from cock notch to peen today, I was dying. I just can't. So don't worry. Well, Law Nerds, we've had a supersized stream. So next week when we maybe stream a little late on the 21st, I know everyone will be forgiving. Don't worry. I will keep you posted on whether we're going to start late on the 21st, but just make a note in your mind that we might be starting late on the 21st. It's going to depend on when I can get to Target, because books. So with all of that, Law Nerds, thank you. It's good to see you. Thank you for being here. Mods, my undying appreciation. At this point, we keep going, okay, but we're going to stream more days a week so they're shorter. And the Law Nerds are like, lol. No, we're not. We're going to start making shit happen. I promise. My brain is still like, no, we're not ready. We're not ready. If I missed your super chatter question, apologies. For all of you that are sharing information, well wishes, and all the rest of it, thank you. Celeste asked earlier, can Proctor be jailed? I have not seen anything that Proctor's done at this point that's illegal. Stuff that violates his duty, yes. Stuff that is illegal, I have not seen that yet. Though I reserve the right to change my mind if more comes out. Based on what we have, this is work disciplinary actions. If more comes out, but at this point, no. Tina KS Leonard said 2025 not getting off to a great start. I hope it gets better. Thanks for all you do. Which is part of why I think I'm just streaming for so long. It's like, let's just be here for the day. Let's just do this. Let's all do this. We need the side chats. We need the sidebars. We need the documents. Law Nerds, we will be back tomorrow at 11-ish. We'll talk about some law stuff. We'll leave more time for questions. I think we will talk a bit more about TikTok tomorrow. Depends on what else happens today. We've got some other cases I want to catch up on. And don't forget, we've got the quick bits to keep it quick, because we don't keep it quick here at all. But how can you body double a full workday if I stream for an hour? You can't. We need to stream the full day. All right, I'm going to go see what's going on with my kid's backpack, and if I need to make a run to Target or send him to Target. He has a car. I can send him to Target. So I'm going to go see what we need to do about a backpack. Law Nerds, thank you for being here. Thank you for being a Law Nerd. You are amazing. I appreciate you. Best community on the internet. We've got lots of questions about the law, and 2025 is starting off wild. So with that, you guys, I will see you tomorrow. Don't forget to get the Law Nerd app so that you stay in the loop at lawnerdapp.com. And let's pull up the outro and let's roll. Good to see you guys. Bye. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.